Your Lordship, I am mentioning, my lord. Yes, as per direction, my notice has been given, my lord, for upgradation.
Give the number.
I am mentioning one matter
Same pair, my lord. Same pair upgradation with
which
notice.
was heard on 18
Yes.
as mentioned matter. Actually, hearing has been concluded. Only your lordship wanted to see the order of the electricity, copy of the electricity for which it has been moved. And that did my lord's pleasure was to direct that the matter will remain its position as mentioned matter. But unfortunately, it has gone at the bottom of the listed motion. So let it appear
Please,
tomorrow.
Are you mentioning upon notice again?
Yes, my lord,
Give the number.
it was ordered to that effect.
Give the
in
number.
presence
please.
of
Yes,
everybody.
please.
The extension of interim order expires on without, it will expire. on-
Upon notice.
Yes, my lord.
No, one thing I have not given notice today, but I will inform personally.
No, 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 no.
Yeah, I permit to mention, Lordship.
Your lordship can see, it has been ordered that it will
I
appear.
understand, sir, but please mention upon notice.
My lord, I am
Mention. Item number 25, my interim order is expiring on 31st, my lord.
Item number
25, Lordship, please, my
will
lord.
be called. Please wait.
My interim order is expiring on 31st.
Yes, please wait. It will be called. 25 will be called, isn't it?
Lordship, interim order expired on 31st, Lordship. The matter is running under the heading, Lordship, hearing, Lordship. Item number 832 and
Are you
830
mentioning upon notice?
upon notice, Lordship.
Extension of your interim order, Shantanu.
And Lordship,
my lord,
contempt application. Contempt application.
Give the number.
my lord,
Permitted to mention, my lord, this matter filed on 2nd January. And my lord, date was given 10th January 2024. And my lord, this matter did not turn, my lord, on 10th January under the heading new motion. And they subsequently it appeared under the heading motion, my lord, of 565. My lord, let it be appear in the under.
Are you mentioning upon notice?
Huh?
Upon notice?
My lord, this is the first time. I
Are
do
you
not know who is
mentioning upon-
appearing. Who is appearing? First date, this matter will appear on 10th January.
Give,
Well,
give
did
the
not
number.
turn.
Give the number, please.
my lord,
Shantanu,
permit I
new
mention
motion.
for my lord.
New motion, लिस्टर पे क्यों न्यू फाइलिंग है तो न्यू मोशन नहीं आएगा जो भी शिफ्ट फाइलिंग न्यू मोशन दे देंगे
My lord, permit I mention, my lord, for upgradation. My with notice I have mentioned, my lord, for
What
upgradation.
is your urgency?
Urgency, my lord, the my private respondent filled up the font, my lord. I have made the objection before the BLRO and also
Give the number. Give the number.
I'm getting.
My lord, may I be,
Permitted. Yes. Yes. Give the number.
my lord, upgradation.
What is your urgency? By the end of? You're mentioning upon notice? Give the number.
My lord, upgradation.
Interim order expire on
Upon notice?
Yes, my lord.
Give the number.
My lord, may I be permitted to mention a matter, my lord? Item number 721, my lord. It was previously mentioned. This is very urgent matter, my lord. Can it be taken?
What is the urgency?
My lord, the lease period of the petitioner will be expired soon, my lord, in March 2024. And it is pending before the divisional commissionerate for hearing, but it
Mentioning
has not
upon notice?
previously mentioned, my lord, that time.
Today are you
today no.
mentioning upon notice?
No, my lord.
Please mention upon notice.
Permitted to mention. Unfortunately, this matter was filed under heading Group 5. Thereafter, leave granted by Honorable Justice Sogat Bhattacharya, and now I'm mentioning for inclusion. This is matter of 2020. Urgency is that private respondent has raised unauthorized construction upon the
Notice?
upon notice.
My lord, upgradation.
The applications of the market complaint matter. Both the matters are clear that no objection certificate has not been issued by the
Upon notice? Give the number.
Lordship for upgradation, your lordship.
Mention this matter, your lordship. The petitioner has invested more than 1 crore, your lordship, in a land. And he is unable to use that land, and his business will shut down, your lordship.
Upon notice? Give the number.
Lordship for upgradation, your lordship. Upgradation. Petitioner is suffering from high fever and 85 years old.
Yes.
Land acquisition authority to grabbing his property.
Upon notice? You're mentioning upon notice?
First day.
Mention upon notice, sir.
Okay, man. Lordship, lordship.
Wait, yes.
Application from a daily is to be mentioned, and if your notice has been served.
What is your urgency, sir?
Urgency is my entrance has been obstructed and I cannot go on.
You're mentioning upon notice? Give the number.
Lordship for upgradation, item number 581 to 604. The urgency is that
The National Highway Authority is trying to dispose me without hearing my.
Upon notice?
Yes, yes, Lordship.
My lord, now the entire motion list is coming into the mentioning list. Please keep that in mind.
Motion
I
milord
will
for,
not upgrade mentioned matters.
for motion milord inclusion milord.
Yes,
My
I will
lord.
not
Six, my
mention
lord,
matters.
upon notice, my lord, I am mentioning, my lord, section, my lord, 10, appeal is pending before the district.
Just a minute. Is it upon notice to the other side? Serve notice and
My
come.
lord.
Upon, my lord, upon, my lord, I shall serve notice.
Upon notice.
My lord, this is with regard to, my lord, the upgradation, my lord, the section 10, my lord, application is pending, my lord, before the district magistrate, that was not been disposed of. In the meantime, my lord, the order of demolition was passed, that was not been stayed. Upon notice, my lord, I am sorry.
My lord, may I mention 2 writ petitions for extension of interim order? It's expiring on 31st of January. Yes, my lord. Grateful, my lord.
Extension of interim order.
Lordship, land was acquired, portion of my land was acquired, but the demarcation was not made, your lord.
Are you mentioning upon notice?
Yes, your lord. My lord, will you kindly fix the
Yes.
date for this, your lord?
Non-prosecution? Upon notice? Have you served? No. Please mention upon notice.
Kindly,
Please do not mention without informing the other side.
My lord, may I be permitted to mention, my lord, the matter is on. It's the, my lord, the mention matter. Every day, my lord, the matter is, my lord, going, my lord, to be
Mention matter, I cannot help, sir. If there are 50, 60 mentionings per day, I cannot help. You can see the amount of mentioning that's going on every day. What is your urgency? Yes? Yes?
thrown out his, by her, so.
So how does this court have determination? How does it come under group 1? Please get.
Contempt application, my lord, and restoration application, my lord. Contempt and restoration.
Restoration should be upon notice.
Contempt, my lord,
New contempt.
new contempt.
Restoration should be upon notice. Contempt and infamy.
My lord, at the time of, my lord, at the time of dismissal, my lord, no one appeared on this matter. My lord, the matter was dismissed for default, my lord, on 17th of October 2022. My lord, no one is appearing on behalf of the private. There is no private respondent, state respondent, no one appear. My lord,
Give the number, let me see.
restoration.
Lordship,
Number, let me see.
Lordship, may I be permitted to mention, your Lordship, extension of interim order, your Lordship.
Upon notice?
Upon notice, your
Give the number.
Lordship, may I be permitted to mention one matter for correction? Your Lordship, the order was passed by His Justice Honorable SUVRA Talukdar, as His Lordship then was. Lordship, the order dated 23rd December 2019.
I do
I
not
have
have the determination for correction. It is not my order. So please find out which bench has the determination. It has been assigned by the Chief Justice. Yes, please find out and move before that bench.
My lord, may I mention for inclusion?
My lord, I live on 760 of today's list, my lord. We should not put the account of the petitioner, my lord. He won't be able to come this week, my lord. I'm praying for the.
760. Let the matter be called. Why are you mentioning?
Your Lordship, I'm praying for arbitration of the matter. The petitioner's land was being used for illegal mining activities and agricultural destruction, my lord. No, despite repeated complaints, no action is being taken, my lord. Your Lordship, kindly
No
please
action
return.
is being taken by whom?
No, none of the respondent authorities.
Who are the respondents?
Lordship, I do not have the entire cost title, my.
Yes.
I don't have the entire cost title, my lord.
If it is police in action, this court will
No,
not
no,
have
no.
determination.
No, my lord, this is not under police in action. This is a already pending matter, my lord. It's in the item number
Are you
397 of
mentioning
the.
upon notice to the other side?
Yes, my lord. The last date it appeared.
Are you mentioning today upon notice to the other side? No.
My,
Please put the other side on notice before you mention.
My lord, as regard item number 206, 7 and 8, my lord. Interim order will expire day after tomorrow, my lord. I have,
Upon notice to the other
yes,
side?
my lord, I have given.
Extension of interim order. Yes, what is your urgency? Urgency? Yes, urgency? No urgency.
So,
Lordship, may I have your Lordship's kind leave to mention item number 91 of today's list, Lordship. It's that matter where we had relied on that Dollar Industries judgment for the purpose of initiation of tender process with regard to first right to refusal. Lordship, the matter was heard considerably. Lordship had only passed directions with respect to consideration of that judgment that we had relied on. it had fallen from the other side that they want to see whether any appeal has been preferred. Lordship, we've checked, appeal was preferred. Your Lordship's single bench order was upheld.
My lord, your lordship's order was upheld in appeal. But now they are threatening to take coercive steps, though it fell from your lordship.
It's appearing in the list.
Yes, my lord. It's
Item
appear-
91.
Is it
Item
in hearing
91.
matter?
Along motion, group
At the
motion.
motion stage?
Yes,
My lord, item number 91. If it can.
Let me see if I can take up, because mentioned matters, you've seen the list of mentioned matters.
My lord,
If it goes down in the mentioned matters list, then you'll be in more difficulty, I think. Let it remain. Let me see if how far I can take up.
Lordship, for upgradation item number 581 to 604, the urgency is that the National Highway Authority, they are trying to dispossess the petitioners and trying to grab their land without providing the opportunity of hearing. So,
Are you mentioning up a notice?
yes.
Give the numbers. Yes, call the days list, please.
লিস্টটা কল করে দে না আইটেম নম্বর 1 বলে আবার দেখে দেবে না দেবে না দেবে
My lord, this is a restoration application, my lord. This matter was
This appears to be for correction.
yes, my lord.
What
In
is
the
the correction necessary?
correction, my lord, Chayamali Mondol was died. So we have made a substitution application, but in the list, still the name of Chayamali Mondol is.
We have not been served with any restoration application or substitution. This matter was dismissed for default, the writ petition.
This matter was.
Where is the restoration application? I do not find one.
I have filed, my lord.
Yes.
Can 3 of 2023, my lord.
Can 3 of 2023 is in the list?
Yes, my lord.
এই ক্যান 3
My lord, this matter was pertaining to the location of the metro railway station in front of the petitioner's shop room, my lord. My lord, the matter is
Give me a
ready
minute,
for
please.
hearing.
Can 3 also?
কোনো কারণে দেয়নি তো? কোনো কেন দেয়নি?
When did you file Can 3?
My lord, it was filed on 11th of December 2023, my lord.
The writ petition has been dismissed for default.
Yes,
On
yes, my lord,
7th of
on
December.
7th of
So
December, my lord. On
So,
that,
where is your restoration application?
my lord, I have.
Unless you restore the writ petition, how are you asking for substitution? The writ petition is not there at all.
My lord, substitution is not there. My lord, as per the instruction, we have filed a substitution, but the matter is.
Don't you think you should restore the writ petition first?
Yes,
If there is
my-
no writ petition at all, where do you file the substitution application? How can it be considered?
My lord, right now, substitution has been filed before filing of this restoration. my lord.
Restoration file করেছিলেন এদিকে।
Where is the restoration application? 3 কোথায় শান্তনু?
And restoration to apply for. Can 3 of 2023, WPA number 14614. Has been filed on 11th of December.
11th?
11th of December. The matter has been dismissed on 7th of December and it has been
So
filed.
it's within time.
Yes, my lord.
But we have not been served with the.
Serve the copy.
My lord,
This is bad practice. You should serve copy. This is a restoration.
my lord, right now, I don't have the affidavit
You
of
want to wait
service.
for the copy? Why don't you give him a copy here and now?
My lord, right now, I don't have an extra copy, but in the course of the day, I'll give them a
Not
copy,
today?
my lord.
Not today.
Full, my lord.
Please come back tomorrow after service of copy.
I'm grateful, my lord.
Item next. Inadvertent error has crept into the order passed on November 22, 2023. Paragraph in the said order. Messrs. ওইটা দিয়ে দেবেন যেটা করেছেন, Trust and Engineering India be read as correct টা দিয়ে দেবেন। Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on November 22, 2023. Urgent certified website copy. This is for different. Can this urgent certified website copy. Yes, next. Item number 3.
Disposed of matter. Disposed.
Why is this appearing?
It was disposed of on 12th December, man.
Yes. Is any correction necessary? 22273. এটা কেন এসছে? No order need be passed. Next.
I'm not going to disturb it. It was for extension of time. I'll take some time while I can ask.
I don't notice.
Yes. And my reply may be accepted, my lord.
No, have you put the other side on notice for extension of interim order? Yes. None
Now it is ready to appear for hearing, my lord.
None appears for the respondents.
Here is the notice, my lord.
Paragraph
Copy of-
affidavit in reply submitted on behalf of the petitioners is taken on record. Paragraph, let the matter appear under the heading Group 1 hearing on 28th February.
28th February. Well, interim order may be extended
Paragraph.
till the hearing, my lord.
Interim order granted earlier is extended till 31st March or until further orders, whichever is early.
Well, let it be kept in the record, the notice, otherwise the author. Kindly record it, my lord, otherwise notice served.
শুধু শুরু তো non appears এখানে করলাম না ওখানে হ্যাঁ কপি অফ হ্যাঁ despite service despite service of notice
এই অপোজিশন দিয়েছে তুমি সার্ভিস করেছি কবে এখনো কোনো রিপ্লাই দেয়নি এটা ফাইল করে দিতে হবে ফাইল করে দেবো
Next.
আর ইন্ট্রিম অর্ডার এক্সটেনশন চাইছে পিটিশন করেছে
In this matter, I am for the petitioner married. This is a evening service.
Opposition.
In terms of your lordship's order, my lord, opposition has been submitted by them and reply also have been served to them.
Reply ko the service করেনি তো
I have not yet received any reply. Our affidavit is here. Hey, now to bhai.
Opposition.
the opposition
Yes.
Reply to that. Copy to that.
But here I've got some urgency, my lord. Thank you, my dear.
I have already served a copy of the reply.
now
হ্যাঁ।
just now
ঠিক আছে ঝগড়ার কি আছে দিচ্ছে নিয়ে নেবে।
তোমাদের নিজের সম্পত্তি
এটা বলবেন না এটা বলবেন না উই আর অ্যাডভোকেট তার মানে নিজের সম্পত্তি
আচ্ছা চুপ কর এত বড় চেয়ার নিয়ে একটা ঘুষি মারলে মরে যাবে।
লোক মরে যাবে 15 বছর ধরে আছে একই জায়গায় হ্যাঁ মানে ready to fix on any date, my lord.
Yes, I've got some.
Interim order may be extended.
affidavit of service affidavit in
My respected senior brother has no attendance.
affidavit in reply submitted on behalf of the party are taken on record. Paragraph, let the matter appear under the heading Group 1 hearing on
Some urgency.
12th February.
My lord.
Paragraph, interim order granted earlier is
Sorry.
extended till 31st March or until further orders, whichever is. The hearing matter will take some time.
12th February মানে
কেন কোন আপত্তি
February
আছে?
31st.
একটু পরে হলে ভালো হতো
আর না তোর মেয়ের বিয়ে তো হয়ে যাচ্ছে
হয়ে গেলে কি
চলো।
হবে?
ভালো করে এ করে দে, মেয়ের বিয়ে
You want it in the next week? You want it in the week after that, Monday?
No,
Only week but only on 20th.
31st আমাকে এই নিমন্ত্রণ করেছে
No, only
এটা আমি খাবো না নিমন্ত্রণ করেছে ভারী হয়ে যাবে
মানে can it be 20th man? My lord.
Tuesday,
ঠিক
it has
আছে,
to be,
বাবা,
it has to be 21st in that case, 20th.
21st.
Omlan, 21st.
21st
Right. Grateful.
May I leave now, my lord?
And grateful to
Next.
my-
Yes.
But I am the petitioner in this matter. Earlier occasion, your lordship directed the
Refer number 4, Lordship, to do the demarcation.
to do the demarcation, whether they have
একটু সামনে এদিকে
That has been done in presence of both. So the typical copy of the report.
The report is not ready as yet. You are appearing for the KMD.
Special land negotiation.
State. That is the state. The KMD. And the
Senior Shottaji Talukdar
Howrah
is appearing.
Municipal
I am for the
Corporation are appearing. Let the report come before the court. Otherwise, we cannot make out. It was done in the survey was in your presence. No dispute with regard to that.
In presence of petitioner as well as the National Highway Authority.
Please let it
My lord, if it be taken up, my lord, tomorrow also, my lord, it will come.
You can.
I'll receive it by today only, my lord.
You can come back with the report tomorrow.
My lord, surely. My lord, it is already there with me, the soft copy.
So let it not today. Madam.
I have no objection.
Will you please serve the report by today
But-
so that the petitioner can go through it?
My lord, then my lord, your lordship, probably my lord, your lordship, interim order was 29th.
এটা পাশাপাশি যাওয়ার পর আসবেন কি?
Interim
My lord, he is stuck up in the traffic. My lord, if your lordship kindly passes over for just half an hour. My lord, I know that's why.
Call the matter after
Can it
700
be on
matters.
6th?
That
Can it
is.
be on 6th?
No, sir, not to do. Let it be not today only.
As I have no objection, anything I have no.
You to serve the copies by today so
Madam,
that the others they can.
My lord, I'll hand it over.
Not today. Next.
So can it be written in its position?
That's why I said not today. It will retain.
I appear for the petitioner.
What is the application number?
Because the application is for
appear for the West Bengal Mill and Paper Corporation.
the application is, I am praying for modification of your lordship's order, earlier order. At the very outset, I make one submission, which is purely a mercy petition, my lord. What happened is,
Which order are you
Achha.
asking for modification?
the order dated 6 December 2023. I am telling why I am praying it. Supplementary list was kept in the record, and on prayer of the petitioner's learned advocate, your lordship was pleased to
Yes.
treat it dismissed as not pressed. What happened in this, my lord, case is the petitioner obtained a mining lease for sand. Renewal was granted, but in the grant order, some time was stipulated for submission of the draft deed, bank guarantee, and the environmental clearance certificate. The petitioner was a bit late to file all these things because of the process of issuance and all these things, not on the fault of the petitioner. Thereafter, due to inaction, it was rejected on the ground of delay. An earlier deed application came up before your lordship. Your lordship was pleased to grant me liberty to make a fresh representation, and a direction was given upon the respondents to consider it on merit. A representation was given, but on the 6th December 2023, due to some communication gap between the client and the learned advocate, Mr. Pallab Chatterjee, who appeared on that day, Mr. Chatterjee was under the impression that in compliance of your lordship, the petitioner failed to give a further representation, explanation of delay. That was submitted before your lordship. Only a supplementary affidavit was given that I made a prayer, I made a reminder. But the delay explanation, which was directed by your lordship, although that was filed, that was not placed before your lordship. Your lordship was
So you can wait till disposal of your representation by the authority. That has not been.
No, that is the difficulty, my lord. The learned advocates are a bit confused. Your lordship was pleased to ask him why you did not utilize your chance. He made a prayer for non-prosecution. That was without the consent of the client, and that was allowed. The difficulty is, my lord, a representation was there. I admit that that explanation given is not so competent as the learned advocates give before the honorable court. But the dates, when he applied, when he got it, and all these things, that was mentioned. If the respondents apply mind, they can understand the explanation. Actual state of affairs is that in compliance with your lordships or compliance of your lordship's earlier order, a representation was given. But upon non-consideration of that, the submission was made and the order was passed. So if your lordship is pleased to recall the order, then I can file a supplementary affidavit annexing that writ application. And if your lordship is pleased to direct them to consider it afresh on merit. Otherwise,
The earlier writ petition was disposed of directing the third respondent to communicate his decision. It's a 22
no,
to 1
that decision was communicated. They are the taken was that the no explanation for delay is given and all these things. So your lordship was pleased to give me a liberty to make a fresh representation, and there was a direction to communicate it. That was done, but that was not properly submitted before your lordship. This is the difficulty. At the very outset, I submitted that it is a mercy petition. এখন চাইছি যে যদি এই অর্ডারটা রিকল করে আমাকে একটা অপরচুনিটি দেওয়া হয়, আমি একটা সাপ্লিমেন্টারি এফিডেভিট করে ওই রিপ্রেজেন্টেশনটা রেকর্ডে আনবো, ফ্রেশ অর্ডার ফর রিকনসিডারেশন অন মেরিট, নাথিং মোর দ্যান। By mistake, that representation which I filed pursuant to your lordship's direction, that is till now not a part of the writ application.
Not part of the writ application as well as not part of the supplementary
yes.
affidavit that was filed on the last occasion.
Yes, that is there, but the representation was filed.
The ground for rejection was delay. That was explained, and the representation which my learned friend says that was part of content the explanation. Mr. Shah,
given liberty to explain the delay before the authority. Yes. You have done that before the authority.
He filed the writ application representation, and there he gave it, but that is not a part of the writ, and that was the mistake on the part of the learned advocate.
You were granted liberty to approach the competent authority with a fresh prayer for reconsideration.
Yes.
So you have done that.
Prayer was made.
So is that pending before the authority now? That representation?
That representation was not considered. That is the case.
So it is a fresh cause of action in that case. Why do
But
you want
the difficulty is that, my lord, it is a continuing cause of action and no liberty is given at there.
Because basically now he is paying for liberty to challenge that order, because when after the rejection order came, this writ petition was withdrawn without taking any leave for challenging that particular order.
Challenging that order is a separate cause of action altogether.
Yes.
So you don't require leave for that. The earlier writ petition granted you liberty to file a fresh application.
My lord. Yes.
What is the prayer in this application?
In this application, I am praying for recalling on modification. If your lordship is pleased
No, the writ application. The present writ application.
In the present writ application.
Not to give any effect to the impugned order. So this impugned order is the rejection order.
The rejection order.
So it has been turned down.
After yes.
And this writ petition was filed against that
that order.
Against that, but it was withdrawn without
obtaining any leave.
Yes.
So if your lordship is pleased to grant some leave to file a fresh application, that will also serve my purpose.
How can that be done? Mr. Shah, what is your submission?
No, lordship, there is nothing on merit he is asking.
No, there's nothing on
With
merit.
regard to original issue that was involved in the writ petition, that is not the prayer of the writ petition in the present can, because the writ petition has been disposed of on the basis of the submission made by the learned advocate for the petitioner.
I am praying, my lord, because
I leave it to your lordship.
Withdrawal was made upon what I can say, total non-consideration of the actual state of affairs. A representation was made in compliance.
Made your can application on merits. Please show me the ground for modification of the order. Because this can application entirely says that the authority went wrong in dismissing your in rejecting your prayer?
Yeah, my lord, I have taken 5 key points, my lord. Firstly, withdrawal was made without the consent of the party, petitioner.
Yes.
That is one point.
You cannot go into merits of the writ application in,
No,
in
in
the present
this application, I am not going to the merit of
Yes,
that.
because your application deals with merits. That's why I'm asking.
And secondly, my lord, it is on total non-consent fault of the learned advocate, I do admit. It is not a fault of the court. A representation pursuant to the leave granted by your lordship was made, but a wrong submission was made that no, I failed to make the writ application. That is why the ultimate result is the petition is suffering an
How could
injustice.
this wrong submission be made? Because
That is, I do not understand.
representation was made, it was rejected. After that, this writ application was filed. So how do you justify that?
That is a difficulty I do not understand, and he withdrew it without the leave.
Sir, please come. If you want to add something to your application, there should be some ground. You cannot only say that it was without instruction of your client.
That is astonishing for me also. The learned advocate made the submission. He personally, I talked to him, he was told that.
Submission is doesn't really hold water, because you say that learned advocate submitted that there was no petition, the representation was not filed. That is also not the case.
No, that
representation was filed, it was rejected. You have come up against that rejection order in the present writ application.
But I was told
How do you justify?
I was told that the petitioner submitted that no representation was not made, and that is why
You have come against rejection of the representation. This writ petition itself. So this submission could not have been made.
no, actually the representation which was submitted is on 19th of April 2022.
That was rejected on May 20th, 2022. Challenging that rejection order, the writ petition was filed.
The earlier writ petition was filed.
It is 2022.
Last representation.
Presently, there is no separate writ petition. It is that.
It was initially rejected.
Yes.
In 2021.
Yes.
After that, this 2021 writ petition was filed. Petitioner was granted liberty to file a fresh representation. That was also filed and rejected.
Rejected, challenging that this 2022 writ petition was filed.
Yes. So how can there be a submission that there was no representation?
In that case, file a fresh, if he has
a fresh
writ petition, my lord.
He cannot, because no liberty was granted.
Liberty was granted.
Liberty is not there. That is why the difficulty.
And because my lord, cause of action is otherwise. His delay is the cause of action. That was not explained.
Properly
explained.
That was not explained. It was rejected. After that, a fresh representation was filed, supposedly explaining the delay.
So, my lord, he has not any case in this, except that
He has challenged the second rejection in this writ petition, but then he has again said that his client doesn't want to proceed.
in recalling, he has not any right to.
নতুন করলে
You have to
হবে
make
না,
out
নতুন তো
some
করতেই
ground.
পারবে না অ্যাটলিস্ট ওই রিকলিং যেটা চাইবে সেখানে সাফিসিয়েন্ট মেরিটে না গিয়ে কেন রিভিউ করুক
I did not
education
find anything in the application in support of your contention.
তুমি এক কাজ করো একটা সাপ্লিমেন্টারি এফিডেভিট দেওয়ার লিভ নাও
Your application says they ought not to have rejected the representation. That is the part. That is the subject matter of the writ petition.
The impugned order, my lord.
Yes. What is the ground for review?
No, in the I filed the application pursuant to your lordship's order. I filed the representation on 19th of April. In the impugned order, which was challenged in the writ application, there is no mention of this representation, and there is nothing to show that yes, that was
challenged the representation in the writ petition. What have you challenged in the writ petition? It's that second
in the petition. The second order of rejection is challenged.
Yes.
But in the order, that representation dated 19th April is not referred or nowhere it is it can be understood that was taken into consideration and rejected.
Because you have come against rejection of that representation.
No, that point came up, as I am told by that point came up at the time of hearing. Your lordship was pleased to ask whether you have filed any representation or not. And The learned advocate by mistake made a wrong submission that no, I didn't file. But actually it was filed, and it is the case that upon total
Have you
non-consideration of
stated this in your application?
in the application I have stated, kindly come to para 2.
Paragraph 2.
There are 3. Paragraph 2C, that after some, no, that is not. Paragraph 3. The Honorable Justice was pleased to record the order filing the supplementary affidavit, but in the present application, due to bona fide inadvertence, the petitioner's fresh representation filed in terms of the order of the Honorable Court dated 7th April 2022 was not annexed. Made annexed at P6 to the REIT application, that is a wrong drafting. To the present application, it should be, was not annexed. Therefore, the learned advocate appearing for the petitioner failed to satisfy the court that in the order of the district magistrate made annexed at P7 to the REIT application, it was wrongly recorded that no explanation for delay was given by the petitioner. The learned advocate for the petitioner, having failed to satisfy the court to the effect that the liberty to file a fresh application by giving explanation with delay was duly complied with, found no alternative and prayed for withdrawal of the REIT application. It is stated.
Yes, let there be a liberty. Because the petitioner will have no other
Technical issue of the.
yes, petitioner will have no other alternate, no other way out, no other option. Can 1 of 2024 heard learned counsels for the parties. By an order passed on December 6, 2023, the writ petition being WP 11586 of 2020.
2022. 11586 of 2022.
2 হবে। আগে কারেকশনটা করে দেবেন তারপরে was dismissed for non-prosecution upon submission made by learned counsel for the petitioner that the petitioner did not intend to proceed with the matter any further. Paragraph. In the present application, learned counsel for the petitioner submits that such submission was made by learned counsel without instructions from the petitioner, also, since the fresh representation submitted by the petitioner in terms of the order of this court dated 7th April 2022 was not annexed to the writ petition, the learned counsel was under the impression that such learned counsel was not in a position to apprise the court regarding the explanation of delay. Yes. Made by the petitioner in the representation. Stop. The petitioner seeks liberty to file a fresh writ petition on the same cause of action. I'll grant you such liberty.
As your lordship is pleased.
Paragraph. It appears that the present writ petition assails an order passed assails an order of rejection passed by the, where is the impugned order?
Impugned order is at
49 of the writ petition,
page,
passed by the District Magistrate Purva Bardhaman. On 20th May 2022, you are challenging this order?
no, another order is there. 6th May 2022, no,
20th May 2022 is the last.
20th May 20,
Yes.
page 48.
Since dismissal of the writ petition was not on merits, comma, the petitioner ought to be granted liberty to file a fresh writ petition on the same cause of action, comma, otherwise the petitioner shall be remediless. Paragraph in view of the above, the application being Can 1 of 2024 is allowed. Paragraph, the petitioner is at liberty to file a fresh writ petition on the same cause of action as in WPA 11586 of 2022. Paragraph, there shall however be no arrest costs as in certified website copy. Next.
Mr. Sarawat Jamal is appearing for the private respondents, my lord. He is only his legs on court number 18, my lord. If your lordships kindly grant a short passover.
It's not possible in this court.
Nothing
What is
to
the
be-
application about?
No, this is an application for modification of an order passed by your lordship. But this application is filed pursuant to an order passed by the Honorable Supreme Court on 14th of December 2023. Please have a look at page 29 of the application. Right. Now, this may come back to your lordship's mind. Now, this was a proceeding under the West Bengal Highways Act. But initially, your lordship was pleased to 29 of the application. Your lordship was pleased to pass an interim order of stay of operation of the appellate authority's order since it was found to be unreasoned. Then when it was pointed out to your lordship at the time of extension of the interim order that there is an appeal pending in or not an appeal but a public interest litigation pending. Now, in fact, my clients went remediless. So now we had to take up an appeal before the Honorable Supreme Court. Permission to file special leave petition is granted. We have heard learned senior counsel for the petitioners as well as learned counsel on behalf of the private respondents who are on caveat. The private respondents have filed WPA, that's a public interest litigation, before the High Court at Calcutta invoking its public interest jurisdiction for the purpose of elevating the issue of waterlogging in Uttar Ramnagar, South 24 Parganas. It appears that during the course of hearing of the public interest litigation, it was reported that 50 to 60% of the road land of 3.5 kilometers had been encroached upon by raising roadside structures. The state authorities were accordingly directed to file a status report along with time-bound schedule for removal of these encroachments. The petitioners are the persons who are alleged to have encroached upon the public road. Since demolition or eviction orders were passed against them pursuant to the directions issued by the High Court in Peel jurisdiction, they applied for their impleadment in the pending PIL. However, with the order dated 29th August 2023, the division bench declined to accept their prayer on the premise that they have separately challenged the eviction proceedings in WPA number so and so. This is before your lordship. When WPA 20904 came up for hearing before a learned single judge on 15 September, the ad interim stay order granted earlier was not extended in view of the observations made by the division bench on 29th August 2023 in the pending public interest litigation. The resultant effect is that neither the petitioners have been heard in the pending PIL, in which directions for removal of the alleged encroachments have been issued, nor the interim stay against the orders of demolition or eviction, etc., passed against them by the statutory authorities, which they have challenged in WPA number so and so, has been further extended. The division bench in the pending PIL has thereafter passed the impugned order dated 16th October 2023, taking note of the statement made by the learned Advocate General to the effect that since the learned single judge has not extended the interim stay in WPA number so and so, there is no impediment for the respondent authorities to give effect to the orders passed by the removal of encroachments. The division bench has accordingly directed the authorities to submit a compliance report on the date fixed, that is 18th December 2023. The resultant effect is that without there being any adjudication as to whether the petitioners are the owners in possession of the subject property. 2, the eviction orders passed against them are legally sustainable. 3, the statutory authorities as well as the High Court have failed to observe the principles of natural justice, as no fair opportunity of hearing has been accorded to the petitioners or other affected persons, etc. The structures of the petitioners shall stand demolished in a way rendering their writ petition being WPA number so and so as infructuous. That does not appear to be the interest and import of the directions issued by the learned division bench of the High Court in exercise of its PIL jurisdiction. It may be noticed at this stage that the petitioners have taken a categoric stand before us that they are the owners in possession of the land in dispute. For the reasons aforestated and without expressing any views on merits, we direct that let status quo re-demolition of the existing structures be maintained for an initial period of 4 weeks. The petitioners or other affected persons shall meanwhile be at liberty to seek modification of the order dated 15 September 2023 passed in WPA number so and so, and or challenge that order in the intra-court appeal. The learned division bench hearing the PIL being WPA so and so may also consider the desirability to defer the submission of compliance report till the fate of the application or intra-court appeal, as the petitioners may move within the stipulated period or by 31/1/2024 is decided, whichever is earlier, the special petition stands disposed of.
So status quo was granted. That needs an extension. Who is appearing for the respondents?
It is the main respondent. I am for this.
Yes, since have you seen the observation of the Honorable Supreme Court?
I appear for the respondent number 3, my lord.
Yes.
We have seen it. My lord, subject to, my lord, what falls from your lordship, my lord. My lord, my interpretation is some protection may be given till such time we file our affidavit that my lord decides the matter. I will kindly not record it, but initially my lord did not extend the interim order considering the order of the division bench.
That's clarified by the Honorable
That has been clarified. So, my lord, till we file our affidavit, or my lord can hear out the matter without affidavit if your lordship so desires.
I don't think affidavits are required in this one.
But it may be required because the main question are twofold. Number one, whether it's a panchayat road or not. Number two, whether we are the right landowners or not.
Lordship desires, we can come with the records, whatever you, the honorable court desires. You know.
And the appellate order is wholly unreasonable.
The issues have also been set out by the Honorable Supreme Court.
Yes, yes, my lord.
These three
They have claimed to be the owners, my lord. They have claimed to be the owners.
And you have annexed
the record of rights.
Documents. Yes. Record of rights.
Not it's possessory right. Possessory right, of course.
But you claim to be owners.
Right. But there are twofold aspects. Not one is whether we are the owners. Number two, probably this is not to be decided in a summary proceeding before the executive magistrate under the State Highways Act. Number two, not whether it's a PWD road or a panchayat road.
Why did you come back on affidavits in that
Well,
case? And till
well.
disposal of the writ petition, let this order be accepted.
Well, my lord, we kindly fix a date for this, my lord, of filing the affidavit and then hearing of the matter. Otherwise, it might not come.
2 weeks.
3 weeks, my lord, will kindly give us.
Heard learned counsels for the parties. Huh? Canon.
Yeah, my lord's kindly leave, my lord. May I have my lord's kindly leave, my lord?
Yes, yes. Heard learned counsels for the parties. The WP along with CAN could be the actual combined order for each. The order passed on September 15, 2023 was carried in appeal by the petitioners before the Honorable Supreme Court. And
That 16th October order was carried up in appeal. The division, the Honorable Division Bench order was carried up in appeal before the Supreme Court.
not this order.
No. 16th October 2023, in the PIL, the Honorable Division Bench did not allow our impediment application and directed this report to be filed for compliance of the demolition. 16th October appearing at page 27 of the application.
So, disallowing the intervention application has not been interfered by the
It was interfered.
Have you been allowed to participate in the PIL?
No. That's why the court granted leave to apply for
Sometimes,
modification.
Yes, yes. Learned counsel for the petitioners has placed reliance on an order passed by the Honorable Supreme Court on 14th December 2023, wherein the Honorable Court was pleased to grant an order of status quo with regard to demolition of the existing structures for an initial period of 4 weeks, and granted liberty to the petitioners or other affected persons to seek modification of the order passed by this court on 15th September 2023, or challenge that order in an intra-court appeal, intra-court appeal. The relevant portion of the order is set out. Paragraph 11, for the reasons aforestated. Okay, whichever is earlier. Page 31, 32, application. Paragraph. In view of such order, comma, the petitioners have prayed for modification of the order passed on 15 September 2023. Paragraph.
In prayer portion, my lord, modification has not been prayed. Prayer page 17. As if it's a prayer for stay.
Correct. That was the order which was initially passed.
There is actually no prayer for modification.
It's not. Please see page 23 of the application. That will probably clarify all issues.
No, that's the earlier order.
Yes,
but there should be
which
a
was
prayer for
refused to be extended. Which was refused to be extended.
There should be a prayer for modification.
But modification would mean reimposition of the interim order. That's what I have prayed for. But your lordship did not extend the interim order. At page 26A. Please see 26A.
After this order of Supreme Court, my lord, this order was placed before the appeal bench, public interest litigation bench, and that bench was pleased to adjourn the matter sine die with a expectation that the matter would be resolved by your lordship.
Yes.
So unless this is complete, that will remain pending. So my lord, I would be praying for lordship that a date be fixed.
That's what I
because my lord, nobody is
You want to come back on affidavits.
nobody is disputing his, my lord, ownership, but there is an extension by encroaching 11 feet or something from his own land that can be ascertained by way of joint inspection, by presence of the server of state authority or the competent authority as well as server of the petitioners. The matter would be sorted out by this way. That is my.
So all the orders have to go there.
No,
orders passed by the executive magistrate.
Let it be kept before kept pending for lordship.
When it is found that you have encroached upon a.
Because that has already been written in the DM's order.
I still have my doubts whether affidavits are built. That will only prolong the matter.
Because DM already said there is an encroachment.
Your documents are on record already. Why don't you come back with reports in the form of affidavits? Without
Very well.
evidence
That's
in
for the
opposition.
state. Yes.
That saves time.
Yes, ma'am.
Paragraph. In terms of the order passed by the Honorable Supreme Court, comma, এটা কেটে দিন Accordingly, the order of status quo passed by the Honorable Supreme Court be extended till disposal of the writ application. Paragraph. Let the writ application be. Let application.
May I submit this? Not in view of the order passed by the Honorable Supreme Court, your Lordship may be pleased to reimpose the interim order, because not an order passed by the Honorable Supreme Court probably cannot be extended by the High Court.
That's a technical.
That's a technical area.
In terms of the order passed by the Honorable Supreme Court, let there be an order, let the same language.
Yes.
Let there be an order of status quo upon both the parties in respect of demolition of the existing structures till disposal of the writ petition. Paragraph, let the writ petition appear under the heading motion on 1st February.
1st February. Today we are on Malad 29.
29th January.
You need some more time. State.
The state wants to file a report in the form of
a fortnight
Yes.
time, I think.
Learned counsels for the respondents seeks to submit reports in the form of affidavits in this matter. Paragraph, let the matter appear under the same heading on fortnight. 12th.
My Lord, if it is convenient to your Lordship as submitted by Mr. Chatterjee, my Lord, it may be 3 weeks instead of 2 weeks.
Yes. I'm not calling for affidavits. I'm calling for reports in the form of affidavits. Annex the relevant documents to it. 12 February, fairly at the top.
Great.
Can dispose of.
Report in the form of affidavits in the meantime. Grateful to you.
Next.
My Lord, 9 is my Lord Vishru Bishas. My Lord, in this case, my Lord, he is engaged in hospital for his mother admitted. My Lord, kindly not today, my Lord.
I am for the next contempt, my Lord.
Contempt matter.
On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th February. Is it complied?
No, my Lord. We have preferred an appeal, my Lord.
That appeal also.
Next.
Inspector appearing on behalf of the petitioner, my lord. The case of the petitioner is, my lord, the petitioner is an absolute owner of a land.
Who is
My lord,
the respondent?
I appear for the KMD. My lord, land, my lord, that was, the possession of the land was taken by the state without knowledge and without due process of law. And thereafter, my lord, the petitioner moved.
The report of the state?
My lord, reporting from a lawsuit director has to take my lord, the instruction whether notice has been served upon the my lord, petitioner or not. My lord. From the record, we could not my lord, ascertain, but no record is available whether my notice has been served on.
You sought further extension of time. It was allowed as a last.
Yes, my lord, but there no record is there. That is why I put on.
No report. I'll record that you do not want to file a report. Yes. What is your case about?
That was the petitioner moved an writ petition before this honorable court, and your lordship was pleased to direct the Special Land Acquisition Howrah to consider the representation to be made by the petitioner. The petitioner made the representation before the Special Land Acquisition of Howrah. That was considered and passed an order. The petitioner preferred this writ petition from that order, my lord. Kindly see, my lord. Kindly come at your lordship. Kindly come at page
68 is the impugned.
68 onwards, my lord. My lord. May I kindly come at page 70, my lord. May I read the observation?
The relevant, yes, relevant part.
My observation from official records, in LA compensation list, one Satish Mali, son of unknown Pakudia, in whose favor LA compensation was declared for arrest plot number 835 area, 0.185 acre, Bagan, Mouja, Khalia,
such and such. The ALA compensation value 99.2484 through check bearing number such and such given to landed court Howrah under section such and such. The check was expired and letter was sent to Treasury Howrah 2 from the office of the Central Administrator Howrah for the cancellation of said check by member such and such. My observation from the records produced by the petitioner, R.S. Arwar Srimanto Chakraborty, son of Damodar Chakraborty, is recorded owner in full share of RS plot number 835, Moja Khalia, GL number 06, PS Bali, classification Bagan, Khotiar number 390. Affidavit affirmed before the Executive Magistrate Court dated 23rd August 2022, Sri Gopal Chakraborty, son of late Srimanto Chakraborty, Bhil Khalia, Post Office Chamrail, PS Lilo, District Howrah is only one legal heir of late Srimanto Chakraborty. My observation from the RS Arwar produced by the BLLR of Bali, Jagacha White, memo number such and such, authenticated RS Arwar Srimanto Chakraborty, son of Damodar Chakraborty, is recorded owner in full share of RS plot number 835, Moja Khalia, jail number 06, PS Bali, classification Bagan, Khotiar number 390. My observation from the inquiry report submitted by C.A. Chakraborty, Assistant LAO. The report dated 13th October 2022, 7 November 2022 and 14 November 2022, no person named Satish Mali, son of unknown Pakuria was there in Khali and Pakuria Moja's last 340 years as per local villagers. As per above observation, it is to be concluded that no person named Satish Mali, son of unknown Pakuria, is there in Pakuria and Khalia villages. Probably that the then time the name Satish Mali was included inadvertently in LA compensation list, where NV means not verified was written in the list against the name Satish Mali. As in RS Arwar, the name Srimanto Chakraborty, son of Damodar Chakraborty, is recorded on it in full share of RS plot number 835, Moja Khalia, jail number 06, PS Bali. LA compensation is to made in favor of Srimanto Chakraborty.
Admitted your entitlement.
I am entitlement, but no notice was served upon me. Without due process of law, possession of the land was taken by the state authority. I am, from the very beginning, the petitioner was an unwilling person, my lord.
The land is in possession of the KMDA now?
Now KMDA.
Land is in possession of the
Yes,
KMDA
yes,
now?
yes.
Yes.
It is
What?
admitted that the land has been acquired without service of notice upon the petitioner. It has advertently, my lord, it has been issued in favor of some other person. Now, my lord, he is entitled to compensation. My lord. At this stage, my lord, the land should not be, my lord, returned because it has been utilized. Position has been taken, land, my lord, acquisition has been completed, and it has been utilized by the, my lord, requiring body. Now,
how has it been utilized?
That the KMD has been utilized.
Still vacant, my lord. I have instruction.
But KMDA has specifically stated in the reason order it has been recorded that the possession cannot be returned back.
No, but why? What has the KMDA done with the land? Yes, Mr. Talundar?
Yes, unless you kindly take up our report.
Yes.
This land was acquired, my lord, in the year 1986 in connection with the LA case of 32 of 1986-87. Possession was taken, my lord, on 28 February. No. Yeah. Possession was taken thereafter. Yeah, section 4(1)(a) was issued, my lord, and on 28 February 1990, which was published in the Gazette on 6th March. Thereafter, possession was taken on 24th May 1998. And this was, my lord, acquired along with many other plots of land in connection with that LA proceeding.
Yes.
After the proceeding was concluded, the state conveyed the land in favor of the KMDA for execution of the project. It was acquired in connection for the purpose of construction of a project that is West Howrah Township project. And that deed also I have annexed with my my lord report. Lordship will find from our report at page 6 the notification
that is 41A notice. And thereafter, Lordship will find the deed of conveyance, which was the possession certificate at page 7, 8, and thereafter, Lordship will find at page 9 the deed of conveyance executed by the state in favor of the KMDA for execution of the project. So my lord, it is the acquiring authority who is to observe the formalities in regard to the acquisition.
Admittedly, it has not been observed.
My lord, here, as it appears from the reason order passed by the collector himself, my lord, that the award was passed. It is not a fact that award was not declared. Award was passed. And it is not only the petitioner's land was acquired in connection with that LA case. Many other plots of land, vast area was acquired in connection with the LA proceeding. But in respect of the petitioner's portion, my lord, someone's name is appearing instead of the petitioner. That is what is admitted now. My lord, in my respectful submission, I have also stated in my report, paragraph 6, Lordship, kindly have a look. That it can't be said there is any illegality in conducting the land acquisition proceeding is concerned. It can be, my lord, for somehow, my lord, the state is contending that inadvertently the name was not, the petitioner's name did not appear.
No notice upon the petitioner before taking possession, 4(1) not complied with. Isn't this illegality?
My lord, had it been, my lord, subject to my lord's consideration, my lord, had it been a single plot of land, certainly, my lord, that would vitiate the proceeding itself. But in the instant case, like the petitioners, many others, land was acquired. In respect of the petitioner only,
Please return the land
Lordship,
of
kindly have a look, the 41A notice. Lordship, the quantum of land sought to be acquired. Lordship, kindly have a look, page 6 of my report. It is not only that very plot, the portion of that very plot. Many other 19, more than 19 acres comprising of various plots of land was acquired in connection with the LA proceeding. And there was no such complaint from others. And this irregularity has happened, my lord, in respect of the petitioner only. So it can be, in my respectful submission, it can be an irregularity, not illegality, for which the acquisition proceeding can be said to have been vitiated. And my lord knows that the recent judgments of Indore Development Authority also, my lord, I was unfortunately, I have
It is not applicable in this case, Mr. Talukdar.
No. One paragraph, my lord, I would like to, my lord, place, my lord, where it has been categorically stated. I have not, my lord, I forgot to.
What is stated in that paragraph?
That such an incident, it can be, if there is some sort of lapse of like this nature, it can be considered as an irregularity, not illegality. And there, in that case, Indore Development, another case of majors was referred to. I will cite, my lord, these two decisions. I'm sorry, my lord, I haven't brought.
Let Mr. Talukdar come back, because I'm really not convinced. I propose to direct return of the petitioner's land, declaring that part to be illegal. Void.
Return can be said the error on the part of the respondent authority, state authority.
You take away a person's, an individual's land.
We have
you say error?
declared the award in the name of some other person. That is inadvertent.
No notice.
That notice has been issued in the favor of some other person. We have issued notice.
Why should the petitioner suffer?
Well, that is why
to get back his land.
That is entitled to compensation. They are also entitled to interest.
Land of Mr. A and you serve notice.
That is inadvertent. We are admitting that is inadvertent. That is error on our part, my lord.
This is an illegality.
No, my lord.
I propose to return to direct return of the land. So let Mr. Talukdar come back if he can satisfy that there is some provision legacy.
Only I will cite these two decisions, my lord.
Heard learned
And
counsels for
page
the parties.
54, they have stated in their comprehensive representation, they are willing to take the market price of the land.
The present market price, page,
Page 54, is the their comprehensive
Page
represent 54, my lord. Last paragraph.
but this representation has been rejected.
So we have considered this representation and passed the written order. Against that, they have come, my lord.
It was
But their
rejected.
prayer was that, my lord,
Not rejected, not, they did not respond.
They did not, state did not respond, but in the reason order, they have said
99,000 and odd can be
which
paid
was
to the.
which was assessed in favor of that person. That can be given to this petitioner along with interest.
This really makes sense, Mr. Talukdar. It was assessed somewhere back.
My lord,
Are you
it is
ready to
not-
pay the market value?
My lord, it is neither deliberate nor intentional. It has, but somehow it has happened.
Petitioner cannot be suffered for that.
Whether
The
he is
representation
also
is at
interested.
page
He is also, page 54 is the prayer, my lord.
50?
54.
50, my lord, dated 8/7/2022,
Page 50.
page 50.
Page 50 is the comprehensive representation and their prayer is at page 54, my lord.
Here is the 54th, but this is the starting from
50.
50, page 50.
I state that if it is not possible to return my land in the event you are requested to give me fair price at present market value.
Letter date
Along with
8/7/2022.
return may not be possible because we have executed the project.
Are you ready to pay compensation in terms of the present market value?
But present market value is not possible, but he is entitled to my interest as per the land acquisition manual now. And there are several provision, my lord, solution is there, my lord, interest they are entitled. My lord.
You have been enjoying the petitioner's land for so many years without acquisition.
My lord,
Acquisition has been done, my lord. Acquisition done, award declared, inadvertently in the name of some other person.
my lord, in that case, my lord, either there
Options. You have to either return the land to the petitioner, his portion, or you have to pay him compensation in terms of the present market value.
my lord, in my respectful submission in view of the law laid down by the Supreme Court, my lord, he is entitled to higher interest on that
note
compensation amount. Assist. My lord, I'll show you, lordship, the judgments, then your lordship kindly consider. What has happened, we cannot.
Heard learned counsels for the parties. It is not in dispute that the land of the petitioner was acquired by the state respondents without service of notice upon the petitioner, and compensation was declared in favor of one Chotish Mali to the tune of rupees 99,284. Stop. In considering the representation submitted by the petitioner, the Special Land Acquisition Officer, Howrah Improvement Trust, Howrah, by an order passed on
7th of December 2022.
7 December 2022, admitted that the petitioner that the predecessor in interest of the petitioner is the owner of the plot in question, and
আমি তো 9:30 সময় চলে এসেছি 9:30 ফোন করছি ফোন ধরে নিয়ে গেছি বলে দিলাম 9:30 সময় চলে এসেছি
is entitled to the compensation which was wrongly declared in favor of one Shotish Mali.
তখন তো চাকরি না থাকলে সম্পর্ক আছে বলতে
Paragraph. The petitioner seeks restoration of possession of his land. Paragraph learned counsel for the KMDA submits that since the land has been utilized by the KMDA, the authority is not in a position to restore the land.
Lordship,
The
kindly,
petitioner-
kindly do
Stop.
not, kindly do not record this at this stage, because in report I have not disclosed on instruction, my lord.
It is your
Perhaps
position.
it may not be possible to return, my lord. Because I don't have the written instruction that kindly do not.
Paragraph.
It is recorded, my lord, at page 69 in the reason order, my lord, may quote this.
I stated that.
At page 69, at the top, this refers to a letter of KMDA that the suit land may be.
No, a letter was issued.
Lordship, kindly omit that part for the time being. Let me come back. Because I have in my
The petitioner
report,
seeks return of his land. Huh? Paragraph. In view of the above, the respondents are directed to take necessary instructions as to whether they are in a position to restore the land to the petitioner or pay compensation to the petitioner at the present market rate of the property.
my lord may record my submission that this can be treated as an irregularity, not illegality.
Come back, I'll record.
May we come back, my lord, on
Will appear under the same heading on
9th? Can we come back?
19th.
9th.
19th.
19th.
Next.
তোমার কপিটা সেদিন থেকে নিয়ে
Under the heading motion. Under the heading motion. New motion. Yes, next. Yes. The report.
I took some time. And because they give me the details,
Let the interim order be extended, my
the
lord.
last chance,
It's the fourth.
Yes, you've taken
Yes,
several
ma'am.
extensions.
I know, my lord, I took 2 or 3
Learned
times.
counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 22nd February. Paragraph, the interim order granted earlier is extended till 29th February 2024 or until further orders, whichever is earlier.
My lord.
Next.
No, I'm for the petitioner in this matter. This is my ability of service. There is a private respondent, my lord. I have served and obtained the track report.
State.
This is with regard to the allegation of unauthorized construction over the government land.
Give me a minute. You have served all of them?
Yes, my lord. Kindly, I have obtained the tag report also. Item delivered.
Yes.
My lord, the property, my lord, of my plot number 335 and 336 is my property. But in front of my property, my lord, there is a government property, my lord, plot number 339.
62 Act.
62 Act. My lord. My lodge complaint, my lord. The page, my lord, the 33 is my complaint. You will also kindly direct, my lord, the respondent number 6, my lord, to
Page 33.
33, my lord. Annexure P2.
PWD land?
No, this is not PWD, my lord. That is
Government
a government land, my lord. Irrigation department. My lord, you will also kindly come to my second paragraph of my representation. I have mentioned the irrigation department. Since the land is under the Khutian number 1, my lord, the land should be, my lord, irrigation department.
Yes, Mr. De.
This one was.
Affidavit of service. None appears for respondent numbers 9 to 12. 9 to 12 despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have encroached upon government land adjoining his plot, thereby obstructing his egress and ingress. Now, the petitioner submitted a representation in this regard before the concerned authority on 21st March 2023, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the sixth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of which act?
And communication that
Not necessary, because proceeding will be initiated.
proceeding under the 62 Act.
Evidence, yes. So communication will be automatically communicated. Next.
Developed list. Well, you'll also direct a logical conclusion to the proceeding. My lord.
Let them find out first. 62 Act should be followed. Yes.
My lord, item number 13, I am for the state, my lord. I'm paying for some accommodation, my lord, of 2 weeks time, my lord, to file the report, my lord, as directed by this honorable bench, my lord, in the last order, my lord. In respect of the second acquisition, land acquisition, my lord.
So far we are concerned.
Yes. Petitioner? Who is applicable for the petitioner? No one.
My lord, in earlier occasions, my lord, one report has been filed on behalf of the state, my lord, and petitioner was directed to file exceptions to the report, my lord. That has not been filed till today, my lord.
Doesn't matter. Come back with your second report in the
My lord.
meantime. Yes.
My lord.
None appears for the petitioner. Paragraph, learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 23rd February. Same heading under the heading motion.
Second report is necessary because it's
Yes, the second
related to the
acquisition.
second part of
Yes,
the
yes.
challenge.
Under the heading motion. Next.
My lord, I beg to appear on behalf of the petitioner.
Or I am for the respondent number 10 and 11.
Last occasion, my lord was pleased to, my lord, direct, my lord, the state authorities to make their submission what they have done with regard to the land, my lord.
Well, no exception was received by us, whether my lord is filing or not.
The state wanted to take instructions, yes.
Mr. Shantanu Kumar Mitra is appearing in this matter, Lordship. Lordship, he is in courtroom number 41. I am pleading for not to Lordship.
Then, my lord, kindly give a short date.
Exception
Take a-
used by the petitioners
My lord, I have
to the
submitted
report in the form of affidavit submitted on behalf of respondent numbers 10 and 11 is taken on record. Paragraph on prayer of learned counsel for the state respondents seeks further accommodation, seeks extension of time to take further instructions in this matter in terms of the order passed on 3rd January 2024. Paragraph, let the matter appear under the same heading on 20th February.
28th. Grateful to you.
You want an earlier date?
My lord, I
16th?
My
16th February.
grateful to you.
Next.
My lord.
Lord, I put it. Well, 15, 16, and 17 is an analogous matter.
Yes.
And my lord, may recollect the matter was heard at length on last occasion. And my lord, on 20th December, my lord was pleased to extend the interim order till 31st January 2020.
Who is appearing?
I am for the response.
কোনটা হচ্ছে 1025, তাই তো?
In this case, my lord, may recollect that I have last occasions I have read I have placed all the
Yes, the notice impugned is at page 151.
yes, correct. For the impugned notice we have challenged the application as page 175, and my lord
175,
174. No, my lord
151.
151. Yes, 151, and yes, 151. And my lord, the previously, my lord, the on
You're a licensee.
the licensee, my lord, we recollect, my lord, the at length, my lord, hear out the matter, my lord, the on 22nd, previously, my lord, in the year 1990, 1997, there were similar notice was issued, and my lord, this honorable court was pleased to pass an order. And my lord, I have placed the order on the last occasion. That is at page, my lord, page 150. And since 1998 to till 2022, my lord, they did not take any steps. They continuously paid their license fees. I have placed all the license.
The ground for setting aside the notice?
That was my lord, the notice was issued, my lord, in accordance with the law. How they will take possession of a particular licensee. They have those who have constructed the shop. They constructed, not that, my lord, the entire shop was handed over. Only one portion, 5 foot by 5 feet, 15 into 10 feet, and 20 into 20 shops was handed over to the petitioners. And my lord, they constructed the shop room at their own cost on the said land.
The notice was set aside upon consent of the railway authorities.
On the part of the respondent, they said.
Consented to to this order. It was not set aside on merits. Yes.
But but there it is written, my lord, in this petition be satisfied by the Mr. Rina Moulik, the learned advocate for the respondent, submitted the stated before this that notice order dated 31st December 1997 impugned in this petition be set aside by the court. But absolute liberty is reserved to the respondent to again the matter in accordance with law and an appropriate consequential order. And to pass appropriate consequential order. Mr. Bhattacharya, learned advocate for the petitioner, has no objection to this course being adopted. Based upon the aforesaid service, I dispose of the application finally and set aside the above referred impugned order, whereby the petitioners are called upon and directed to vacate the property in question. However, absolute liberty is given to the respondent to act in the matter seeking the recovery of possession from the petitioners from the property in questions in accordance with law. Now, I am showing the notice. The earlier notice was issued by the individual operators. When you compare with these two notices, at page 119, the type copy is there, and page 120 is their notice. Page 120.
Yes.
Railway plot number such as railway station road, area Kharagpur was temporarily licensed out to you under the usual terms of temporary license agreement. I, on behalf of the President of India, do hereby give you upon new notice to quit and deliver a vacant position of the above mentioned railway plot and restore the same to its order.
This is the earlier notice.
Earlier notice. Now, my lord, kindly compare these notices with the page 151. Then absolutely, my lord, the illegal notice again has been issued. In this notice, my lord, without determining the tenancy, straightway, my lord, the one Xerox copy of the notice pasted, my lord, outside the shop room, without mentioning any name, without mentioning many names. They have accepted in their, my lord, the report. See, one Xerox copy. Well, they are trying to adopt a hire and fire theory. Whether this kind of notice at all maintainable in the eye of law. They want, but they say this is our railway property. So whenever you want, we went there, we demolish a shop room, and we take possession of the plot in question. This notice, my lord, purely indicate that particular point.
That's all your submission?
No, my lord. Several other things there.
Yes.
My lord, page number, my lord, there is a, my lord, I'm coming to the original point. My lord, the provision Railway Code of Railway Engineering, clause 1016, I have annexed this position. There is a clause for allotment of plot, considering the socio-economic condition of a country. The Railway Board earlier occasion, my lord, adopted a policy that those who want to carry on business, they will allot small plot of piece of land to the individual shop owners, and my lord, the shop owners will construct a shop room at their cost in the said plot, and they will carry on business. Admittedly, in this case, my lord, in 1979, plot in question was handed over to the petitioners. They constructed the shop room. My lord, they carry on their business. Is the poor persons, my lord, to maintain their livelihood. 1990, suddenly in 1997 notice was issued that was challenged before this Honorable Court. This Honorable Court set aside the notice. Since 1998, my lord, after the order was passed, they issued a notice upon us, deposit your license fees, we paid the license fees, and continuously till 2020, we paid the license fees. Suddenly, my lord, again they issued this kind of notice in the year 2022, challenges before this Honorable Court, and this Honorable Court pleased to stay the impugn order. And my lord, before that, 1984, there was a several clause, Railway Board issued several notices directing that those shop owners, those who are carrying on business, they may apply for change of ownership of the particular plot of land. In our opposition, my lord, we have added that particular circular also. So considering the socio-economic condition, a person may not be in a position to carry on the business because of his ill health and other conditions considering. So Railway Board permitted that circular. And my lord, some father was died, son is the automatically survived.
Applicable in this
Well,
case.
there's the applicability. So, my lord, in page 151, my lord, I have arranged that particular. Through RTI, we have asked them to put our report in opposition. Exception shift.
151 is the notice.
154.
Yes.
As per, my lord, the queries was as per DN headquarters Southeastern Railway KGP 5 notice number WL sales of plot dated 1/4/2009 issued by the concerning authority, general notice to all shopkeeper at Railway Board subject to change of ownership in terms of Railway Board circular dated 25/6/88 and Railway Board circular dated 2004 kindly confirm the above pending notice had been served by DN headquarters. The reply was given to us, jail notice to supply for change of ownership dated 1/4/2009, served from the office of the DN headquarters to the licenses of shop plot holders, Kharagpur Railway Settlement. So, not only, my lord, they have allotted the plot to us. Otherwise, there was a clause for change of ownership that was accepted. And they said, the respondents, my lord, the change of ownership, so that notice was also served.
You say that notice is not in accordance with law.
My lord.
It's a general notice not addressed to you. That is your submission, isn't it? Primarily.
Right. No, I'm just, my lord, the entire scenario. Now they said now, what is the stand? They says, now if Amritbharat project is there, so I want that shop room and we'll use the force to evict us. That is their sole motive. In the report also they says, the Amritbharat project, they want this particular plot of land. Now my another submission is this, my lord. These particular shops, that is not in the under the Kharagpur railway station. That is outside the Kharagpur railway station. Kharagpur is a vast area. Along the road, in front of the station is a wide 40-foot wide road. And from the shop owners, 40-foot wide road in front of their shop room, the 40-foot wide road is there. And totally outside the platform area. This is separate, totally separate area. Entire Kharagpur town, maximum portion sold by the railway authority. There is a railway land. And what this land, we are carrying on with this, my lord, since 1979, after the allotment. And my lord,
there was no formal allotment.
This allotment. I have last occasion, I have placed that allotment letter as well as, my lord, our
At page?
At page, my lord. The type copy is page 161. And my lord, the 160 was the type copy. Our type copy, yes. This is a sample copy. Wait about, I'll carry page 87.
This is in favor of one Mohendra Gop.
So that is, my lord, that is one this particular another same
petitioner at all.
My lord, no, he's not petitioner. In this case, my lord, just sample one copy I have shown to your lordship. But other copies there, I have see page 84, my lord, page 84A. This is the allotment letter.
84 is not legible at all.
84 is not legible, but type copy I have annexed there. Better, my lord, kindly take a page. Lakshmi Narayan. 76 is there and Krishna Gopal Das, page 72. Page 72, my lord, files. Krishna Gopal Das, that is there, my lord.
Yes.
It has been decided to allot the above plot measuring 10 into 15 foot in your favor under the usual terms and temporary license agreement with effect from August 1979. And this is the charges. And if construction of shop of the above allotee is not made done within a period of 1 month from the date of receipt of this plan, the allotment of the plot is liable to be cancelled. This is one of the clauses there. Then, my lord, D, my lord, will find what I submitted for your lordship. The allotee will construct his own structure as per the standard plan and specification supplied by the railway and the layout checked and certified by the IOW South. The prescribed agreement suggests such and such.
Clause G. Clause F.
The railway reserves the right to terminate the license to a short notice without payment of any compensation for the structure built on the above plot. That is there. That is the general that would be written. But my lord knows better than me, my lord. That is general clause.
Part of the agreement which you're relying upon.
My lord. But and my lord, as per there, my lord, the formal allotment later, my lord, we have continuously paid the license fees to them till 2022. In 2014, my lord, the Railway Authority also, my lord, another circular was issued. My lord, page 157, my lord, will find.
Yes.
My lord, the general notice for the licensee of Kharagpur Railway Settlement Market. The licenses of Kharagpur Railway Settlement Market are hereby informed the following. Renewal of license. The original licenses were still in possession of their allotted shop plots. Conducting business therein are required to submit application address to DN headquarters for renewal of the license and execution of agreement duly submitting their photograph identity card, voter card, and Aadhaar card, latest monetary photocopy duly self-attested. If the licensee wishes to submit, please ensure that the shop is free from court case or any other dispute, free from incumbents and no outstanding dues pending in the shop room. Change of ownership. The present occupant, legal heirs, who are still in possession of shop lots and conducting their business on behalf of original licenses are required to submit application addressed to DN headquarters, KGB, for change of ownership due to submitting original power of attorney, legal documents, legal year certificate, affidavits, photocopy of death certificate, licenses, such and such. That is, my lord, in terms of the 84 circular, 87 circular, my lord. This was in 2014.
Because the initial period was 3 years.
Initial period was 3 years, my lord. There is that was extended. There is no formal extension, but was continuously we are paying the license fees. That is automatically, my lord.
Yes.
So, my lord, in the instant case, my lord, one thing, my lord, when a person has constructed a shop room, under which provision of law he will be evicted? That is
Under which provision?
the shop owners will be evicted. But nature and character of the shop, my lord, that is totally different. Because if he is occupying the entire constructed railway plot, that is different. But here in this case, my lord, we constructed the shop room at their land. Undisputedly is in 79.
F, page 73 is very clear.
Clause F is there.
That is very clear. Without payment of compensation for the structure built on the plot. And you are aware of these terms when you enter into the license, isn't it?
My lord.
Can you challenge this now?
And consider the other aspect of the matter, my lord. Whether we are undisputedly in 1997, the order passed by this HON'BLE court. They did not.
That order was on consent, not on merits. Please bear that in mind, sir. The railway authority said, fine, let it be set aside for now, with liberty to issue a same notice upon you.
But the notice was not in accordance with it. That was the primary consideration of this HON'BLE court. The notice which was issued by the railway authority, that was not in accordance with the law. That was a consent. But when this point was raised, my lord, that time they said
the submission was by the railways.
My lord.
That the notice may be set aside with liberty to file issue a fresh notice.
My lord.
Where is it stated that it was set aside on merits?
No, not on merits.
Or since it was not in accordance with law, that is not recorded. Where is it stated? That notice was not in accordance with law. That is also not recorded.
Hmm.
Let us see, Mr. Ghosh.
Grateful to your lordship that your lordship the first rightly pointed out whether there is any valid license agreement or not. My lord, my specific point is this, that there is no such valid license agreement at present.
Page 72 is there.
Yes, my lord. 72, my lord, kindly come page 72.
When was the last license fee deposited?
Yes, that is not license fee. That is occupation charge. I'm coming on that, page 37. It has been decided to allot the above plot measuring such and such in your favor under the usual terms and temporary license agreement. My lord, kindly mark this word, temporary license agreement with effect from August 1979. How long it is effected? Before actual allotment of the above plot is effected, you are advised to pay the following measure amount subject to the Kharagpur session. Then, my lord, kindly come to the next page, D, clause D. So, my lord, the license was executed on August 1979 on temporary measures. D, the allottee will construct his own structure as per the standard plan and specifications supplied by the railway and layout check certified by number such and such. My lord, E is very vital. Prescribed agreement in the executed with the advice stamp of ₹5 by the allottee with the railway within the period of 1 month from the date of receipt of the plan. Once the execution of agreement will lie with the allottee, the agreement will be for a period of 3 years. Phrase agreement is to be executed for further period of maximum 3 years of licensing. My lord, according to your lordship queries also, my learned friend failed to produce any agreement according to this terms of the allotment letter. My lord, this is not an agreement. This is an allotment letter. And according to the allotment letter also, the agreement is to be executed within 30 days.
Have you complied with clause F?
No, I'm coming on that point. For the sake of argument, my lord, if your lordship hold, yes, agreement was executed. Kindly hold that agreement was executed. Even then, how long it will be effected?
3 plus 3. No. Have you complied with clause F? Have you
Yes.
given us a separate
Yes,
notice?
the railway reserve the right to terminate the license at a short notice without payment of any compensation for the structure built on the above plea.
Where is the short notice?
My lord, question of notice is there. That is page 130.
General notice.
Anyhow, my lord, that kindly consider when I can serve a notice upon the person if he is an authorized occupier, if he is had a valid license. I don't know in the name of one Gopal who is occupying. And I have in detail, I have stated in my affidavit in opposition now who are occupying. So my lord, they have no valid license or any agreement. If that was expired long back ago, more than a decade, 79 plus 6, then my lord, maximum 85.
All that is all in your favor. But an individual notice was required.
Yes,
to
my
be
lord.
served.
Then my lord, kindly come to the page.
Each of the allottees.
Page 37 for a moment, my lord.
Yes.
Page 37. So, my lord, my first submission is this. There is no such valid agreement or license. Or if there is also any agreement or license, that was expired 79 plus 6 years. That is in the year of 85. Then, my lord, kindly come to the page 37.
Yes.
My lord, Krishna Gopal Das, the occupation for occupation fees. That is not, my lord, the license fees. Occupation fees. So, my lord, the license fees and occupation fees or occupation charge are quite different.
They are just occupying the land of the railway. That is question of authorizedly or unauthorizedly.
Even an unauthorized occupant has to be served with a notice. Where is that notice?
That notice is 137, my lord.
That is a general notice. That is not.
Yes, my lord. I'm coming again, my lord. Occupation fees for the month of 2022-23. Then, my lord, kindly come. Last line, the receipt is given on the understanding that the occupant will vacate the building at 30 days notice.
Where is this notice?
That notice is, my lord, that is 37, page 137.
That cannot be the notice.
And my lord, kindly consider.
It's 151, I think, the notice. 151.
Yes, my lord.
The entire writ petition primarily stands on one issue.
Yes, my lord. My lord, kindly consider one thing. Now, what is the intention of notice? To inform something to the other, to somebody. So that purpose has been served. When that was served, then I think, my lord, that is a valid notion.
This is not a valid notice. You have to serve individual notices. Otherwise, all the
My lord, how can I serve the individual notice? Kindly see my affidavit in opposition.
occupation charges. Even if you hold
Yes.
them to be illegal occupants, you have to still evict them in accordance with law. So they are entitled to an individual notice.
And my lord, particularly in this respect, my lord, the railway project is held up, my lord. My lord, kindly see my affidavit. Huh?
Due to fault of the railways.
No, my lord, that is in general notice. Whatever, who are occupying valid occupier, authorizedly occupier or unauthorizedly occupier, everybody was served this notice. Because that railway land is required for the project of the railway development.
Served with the notice, please show me the service.
Yes, my lord, that was served by pasting in his sub-room wall, my lord.
Any provision of law which acknowledges pasting of notice as service?
147 according to the 147, my lord, no notice is also required
147
of the railway act.
Let us come to the railway act.
My lord, prior to, my lord, kindly, for a moment, my lord, kindly consider my affidavit in
The
opposition.
petitioners have a weak case, but then notice is required to be served.
My lord, for a moment, my lord, kindly see.
147, let me just go to 140. This is if the person enters without unlawful authority, without lawful authority. This is not applicable in this case at all. You had initially granted them authority. 147 says when the person enters without lawful authority. So the entry was lawful.
At present, my lord,
So 147.
I have stated that, my lord, kindly see paragraph.
147 is not applicable.
My lord, before, my lord, kindly see paragraph 6 of my affidavit in opposition. What is the... Yes, yes.
This is a penal provision
Yes,
to leave.
my lord, kindly see that.
Penal provision.
If any person enters upon or into any part of a railway without lawful authority, my lord, my first line, my submission is this: whatever may be the lawful authority, that was still 79 plus 6 years. Thereafter, they have no lawful authority.
You are relying on the second part, actually.
Yes, my lord. Then, my lord, kindly see. Part of a railway without lawful authority or having lawful entered upon or into such part misuses such property or refuses to leave, he shall be punishable with imprisonment for a term which may be extended to 6 months or with fine which may be extended 1,000 rupees or with both.
So,
then, my lord, kindly see, or refuses to leave.
So where is the provision for
They
eviction without notice?
refuses to leave, my lord. Instead
Ghosh.
of leaving, my lord, they file this writ petition.
So you can punish them. This is a penal provision. Where is the provision for evicting them without notice? You have just now submitted that no notice is required for eviction under 147. 147 doesn't say so. That was your submission, isn't it? That you can.
Then, my lord,
execute
kindly,
without notice
kindly
to
come,
law person.
subsection 2.
Yes, subsection 2.
Any person referred to in subsection 1 may be removed from the railway by any railway servant or by any other person whom such railway servant may call to his aid. So subsection, kindly consider section 1 and subsection 2 together, my lord.
Please serve individual notices.
My lord, my first submission is this: they are not at all the authorized occupier. My lord, kindly consider paragraph 6 of my opposition, my lord.
I think mention matters. Give some other day.
Paragraph 6 of my affidavit.
may I
আমি আগে একটু বলে দিই, তারপর বলবেন আপনি।
We are eating into mention matters time.
অন্য বেঞ্চ আছে
Oh.
It's past 12:30.
হ্যাঁ, another matter fix.
We'll continue some other day. I'll give you a short day. So
may I submit, but kindly make it hard in part and fix up any day. Kindly make it hard in part.
My lord, no question of hard in part, my lord, any day at first, my lord,
1 year, my lord,
or any day.
Hear out it.
My lord, the question
Hearing
of
this matter,
railway
my lord,
railway
kindly make it
project is hampered, my lord. Kindly consider that, my lord.
interim order is till 31st January. Will you come back on 31st January?
No, my lord, in 30th January or my lord, 1st February, any day.
31st.
My lord, 31st, my lord, I have personal difficulties, my lord.
Well, 1st February in that case.
Yes, my lord.
February.
Yes.
Interim order, my lord?
31st January interim order is there already. The next.
Yes,
day
31st
will be done.
January.
1st February.
My lord.
Heard learned counsels for the parties.
At the top, my lord.
Paragraph,
So that
let the
we can
matter
take
appear-
some more
yes,
time,
yes.
my lord.
Let the matter
Objection
appear
was
under the
31st January.
heading Group 1 motion on 1st February 2024, fairly at the top.
Yes. Public.
My lord, may I have your
Okay,
item number 25, my lord.
15, 16, 17, my lord.
Don't take me amiss, my lord, in respect of act number 18, my lord. On Wednesday, I have some personal difficulty. Can be taken up on Friday, my lord.
It's not being called, sir. I cannot fix up dates like this.
Wait,
It's called. If you're not available, ask someone to
The compelling circumstances. My interim order, item number 25, my lord, I mentioned, my lord, upon notice, my lord, I mentioned on last Thursday, my lord, that the matter should be, my lord, 31st March is the interim order still existing, my lord. 31st January, my lord. My lord, for that reason, I'm praying, my lord, let the matter be.
Let it appear as extension of interim order. for the
Item number 25.
I am appearing
That's
for
it.
the respondent.
Item number 25.
I'm appearing for the respondent. 25 Vijay International, right?
Fairly at the
You check.
Interim.
It will taken up as extension of interim order.
Let's see, when it will be.
No, as well as extension of interim order.
It has not been called today. So I think passing an order like this.
Come
Pension matters.
to these.
Yes, 658. He's appearing for the respondents today.
দেবব্রত ব্যানার্জি, সমীর চক্রবর্তী and company. আমি বুঝতে পারিনি very short.
Who is the petitioner in this matter?
Lordship, we are appearing for the petitioners, Lordship.
No. 31.
Who is appearing for private respondents?
Private respondents have not been served by post. However, my lord, they have been served on a number which we are told, my lord, is a WhatsApp number of.
That is that accepted in a court?
We have
A WhatsApp service?
Lordship, actually, it was the last day, in between there is a no working day basically, my lord, for which I have,
Don't you serve and come back?
I've already served by speed post, my lord.
Where is the service? I want to see the service.
Service has not been affected.
And you have not affected any of the track reports?
Yes, my lord, none of the service have been affected by post, my lord, because of these 3 intervening holidays, my lord.
So why don't you serve and come back?
My lord, we have prayed for a, my lord, dispensation of service under Rule 26 of the Appellate Side Rule, my lord.
What is your urgency?
Very serious issue, my lord. By accepted positions, my lord, we are the poorest of the poor. Somehow at the fag end of the road, we are staying there for more than 30, 40 years, my lord. And
Unfortunately, my lord, the petitioner, basically private respondent here, somehow came to the lordship's courts someday, and we are the major responsible who should have been heard. At least we should have been made parties to the cases, my lord. But we have never been heard, never been served with the copies. Subsequently, I have somehow came to our knowledge that I am being evicted out. Then I approached to the assistant engineer, then to the subdivisional magistrate, then to the district magistrate. But my lord, my cases remains totally unheard, totally vitiated, and there is no provision, my lord, when there is the issue of conflict of two, they themselves are the encroachers. And there is the simple grievances, there is the ingress and egress issue. But there is no land, no property, no residence, no residential arrangement, totally distorted facts that was brought to the lordship.
Your status in respect of the plot in question?
My plot is the question, my lord. This is my acceptance that I am somehow at the end of the public road, my lord. And it is for more than 30-40 years.
Maybe that doesn't regularize your.
No, my lord. But I have made several petitions to the authorities concerned. They allow me to stay there, and there is a provision in the Highway Act itself. If I make this sorts of application, if my status is created there somehow, they can allot me a temporary arrangements to stay there. But besides this, my lord, my submission is there is no question of their egress and ingress at this issue, my lord. If there is any issue, and suppression is the very serious issue, my lord, they came to the local magistrate court. Subsequently, in the revision petition, they went to the district court also. There is a specific order on that point. That is the no ingress egress. This is their private interest totally. My submission is not. This is like that of Tagore's Dui Bigha Jumi, my lord. We are the poor upens, and some big landholder requires his lands to be broadened. I have to get evicted.
Give you the liberty to encroach upon government land, PWD land?
No, my lord. This is, my submission is that this is certainly this is my fact, my lord. I am encroacher, but this is the another.
This is our 13th October order. Nothing has happened till date. So please serve and come back.
One submission, my lord. Short stay order may kindly be allowed. We will.
120, page number 120.
Page number?
120, man. 120.
Yes, what does it say?
This is the order of communications. 13th October, we don't know, my lord, when the order was passed. We only came to know by this order of 11th of January 2024. My lord, after that, the police had come to our house, my lord. They have threatened us to vacate the land property. That is the urgency your lordship was pleased to
Any document on record to show your status in respect of the plot? Have you annexed any document?
My lord, all our submissions was duly, with all paper documents were submitted under hearing that
Have
was.
you annexed any document to the record? Please show me. How do you substantiate your claim?
That is the two important documents I can provide. If I am not sure, my lord, whether annexed or not, but two important documents I can provide. If lordship allows, I can give the copy. One is electricity. That has been allowed to the point. Another, my lord, local panchayat allowed me to continue the license, trade license.
Not there, the land.
Land, I accepting this, my lord. This is the land of the PWD. And entire land is not the PWD. Because there is a L-shaped pattern. Some portion goes to the private land, some goes to the BA, and there is no clear demarcation. And question is, my lord, even if then if public cause is there, if I am allowed to asked to vacate the land.
Public cause is not there, sir. You cannot encroach upon PWD.
Certainly, my lord. But the other private person who is having specific interest, he has not come through his public interest litigation. He is a specific interest that I should be evicted out. Even if he himself being the encroacher. My submission is very to that point, my lord.
This is pursuant to an earlier order of this court, isn't it?
This is the thing.
I am afraid no interim order can be granted. Anything to add?
My lord, one line, my lord, one line, my lord. Even if that order, lordship's order is reflected, my lord, in that order, any of our encroachers were made parties in the case. We did not
challenge the order.
I did not have within our knowledge that some order has been passed by lordship. And when I came before the lordships, but by this time, executive magistrate passed the order. We withdraw the case, went to the district magistrate. I made a thorough submission, entire facts and submission made. Then I became the appellant before the district magistrate. Subsequently, another petition was filed before Lordship. And in that second petition, writ petition, I was not made the party. Subsequently, they moved to the district magistrate. With order, they became the petitioner. But when I am the appellant before the district magistrate, where that order has been disposed of, my lord?
Can you, how early, how soon can you serve? I'll give you a short date, very short date.
My lord,
We have already sent by speed post, my lord.
Service, I require the service.
Expectedly 2-3 days, it will reach certainly.
2nd February,
My
this
lord, he
Friday.
challenged the order, page 121.
It's in the order, DM's order.
DM's order challenged on 13th October.
It was communicated in January.
yes.
Yeah, this is the communication, that's page 120, my lord.
So October order communicated in January, so nothing will
Thereafter,
happen
the
in these
petition-
few days. Come back on Friday, please show me the service, that's all, nothing else. Service on all the respondents. State has appeared.
Yes,
So
madam.
other respondents, please show me service, I'll take up the matter.
Lordship, at least the state should verbally assure that there will no serious adverse action against us.
Everything is over, sir, I can find.
Lordship, if this
Since
is my,
October, nothing has happened, so in these few days, I don't think anything further will happen.
if something happens, my lord,
Friday.
my existence, livelihood, my shelter, everything will go, my lord. I will again, my lord, since this is not my choice that I've been encroaching on government's land.
The copy, my lord. I concede to the order that this order should not be scanned.
Yes,
Only for
it's
that
not a
reason.
speaking order at all. I've seen
Not
that. This is not a speaking.
Not a
Anyway, let it be
practical-
adjourned till the adjourned date, next date then. I'll give you a little longer date. Please serve and come back. Let this order be stayed till the adjourned.
Is it, my lord,
Right?
my lord, my lord, my lord.
The petitioners assail the order passed by the District Magistrate Malda on 13th October 2023. This is a 10-4 order, isn't it?
Yes, ma'am.
Under
My lord,
section 10.
no, my lord, it is an order passed pursuant to your lordship's direction in those two writ petition. If your lordship takes up the order at the heading, it is written, hearing in connection with WPA number such and such and such and such. So, my lord, this is a order passed pursuant to a direction passed by your lordship in two different writ petitions.
Has to be 10-4. Anyway, passed by
Our-
the District Magistrate Malda. Stop. The petitioners are directed to service upon the private respondents is not affected. Paragraph. The petitioners pray for stay of the order impugned for the time being, since for the time being on the ground that the order was passed without considering the submission made on behalf of the petitioners. Paragraph.
In
Let
this,
the matter appear under the same heading on 22nd February. Please serve in the meantime. Paragraph.
Short date may be given, but because the order.
Serve and come back.
The
track
14
reports.
and 15, my lord, 3 parts. The Dowlatpur, my lord, same place was there.
Very well. Can you finish off before 9th February? Can you serve before 9th
My
February?
lord, we have already sent. It is
No, the track reports.
Yes, my lord, if your lordship give back the
I've not
certificate of
recorded
service,
this. Please take
then we
this
can
back.
reaffirm it and
Yes,
then.
yes, please take this back. Yes, 9th February. 9th February. What a 9th February. Paragraph. Since implementation of the order impugned shall render the writ petition infructuous, the order impugned dated 13th October 2023 be stayed till the adjourned date.
Lordship.
My lord, one more thing, my lord. My lord, there is an inadvertent mistake on my part, my lord,
What is
in writing the cost title on the zero page, on the page, on the index, my lord, index page, and my lord, on the list of date page, my lord. May I be permitted to?
What is the mistake?
My lord, mistake is I have written it as Gopal Shah, whereas it would be, my lord, Gauri Shah.
The main page it is Gauri Shah.
It is Gauri Shah.
Gauri
Shah.
Everywhere it is Gauri Shah.
So the cost title is Gopal Shah.
In 3
And-
pages, my lord. On 3 pages. On the zero page, on the index, and on the, my lord, list of date page.
Otherwise, every page it is Gauri Shah.
First line, হবে, হ্যাঁ? On prayer of the petitioners, liberty is granted to correct the cause title, index, and list of dates appended to the writ petition by incorporating the name of Gauri Shah in place and stead of Gopal Shah.
I'm so grateful, my lord. Good.
তারপরে next.
Grateful.
Yes.
Yes, Lordship, I am for the petitioner, Your Lordship. In its service, kept in record, Your Lordships.
Served all?
Yes, Lordship.
Mr. Dey is appearing for the state?
Yes, Lordship. 59, so second.
Yes.
Yes, Lordship. Petitioner,
You've not served the panchayat?
Panchayat Pradhan, Your Lordship, served.
Where is it? Executive engineer. Served, yes.
Yes, Lordship. Petitioner and his co-sharer are owner of the land adjacent to the Thakuran Nodi, rivers. Suddenly, Your Lordship, the local Pradhan, with help of the local anti-social elements, Your Lordship, without any proceeding, encroach the land of your petitioner, Your Lordship.
Encroached?
Encroach, Your Lordship, for Thakuran river reforming, Your Lordship. Without any proceeding, without any giving notice to the petitioner, and nothing has been done. I made objection before the all respondent authority to take appropriate step to stop the digging work of the Thakuran Nodi, Your Lordship. But nothing has been done, Your Lordship. Kindly see the representation, Your Lordship, page number. Page 45, Your Lordships. Sorry, Your Lordship. Page 50, Your Lordship. All respondent, Your Lordship, block land and executive engineer has been served, Your Lordship. There is objection. Several representation has been made before the concerned authority, Your Lordship, to stop the digging work without any proceeding or unlawfully and unauthorizedly encroach my land, Your Lordship.
Mr. Dey?
Irrigation department. My lord, this is the jurisdiction of the irrigation department. Yes, must file an objection to the irrigation department. Irrigation department.
Yes.
Irrigation department. My lord, we can file a fresh, my lord,
Press order number 4.
Yes, my lord. I have seen, my lord, irrigation. That is executive engineer irrigation, that is 4 miles. You must file application irrigation department. That is the jurisdiction of irrigation, not DLR or irrigation কে একটা দরকার ছিল
দিয়েছি দেখছি
বাবা আমার কোনো আপত্তি নেই নতুন করে একটা ভালো করে লিখে
Yes, will you file some representation? It has to be before the irrigation department.
Yes, my lord.
Yes,
That is
Yes.
file it.
Your Lordship, I send the demand justice, page number 57 to the executive engineer, irrigation department, your Lordship.
Demand of justice cannot be considered.
In the mean, yes, Lordship.
Why don't you file a comprehensive representation before the authority, before the irrigation department?
Yes, Lord.
And no further encroachment will be done till disposal of.
Some portion, your Lordship, some portion has already been encroached by this such irrigation department, your Lordship. Too big.
Let there be no further encroachment till disposal of the representation.
Yes, sir.
Affidavit of service. Paragraph, none appears for the eighth respondent despite service. Paragraph. The petitioners claim to be recorded owners of land adjoining the Thakuran River, Thakuran, Thakuran River, and complain that the fourth respondent, comma, along with the local panchayat authorities, has started digging earth from the petitioner's /apostrophe land for the purpose of reforming the river without acquiring the land by due process of law. Stop. The petitioners seek to submit a comprehensive representation before the fourth respondent in this regard and pray for a direction upon the said respondent, SAID, to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent within 2 weeks. Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 1 month. 2 weeks. Within 2 weeks. Within 2 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, pending disposal of the representation, comma, the respondent authorities are restrained from causing any further encroachment upon the petitioner's /apostrophe land in any manner whatsoever.
Your Lordship, may I permit one line, your Lordship, here. Your Lordship, if any portion has been acquired by private respondent authority, your Lordship, restore the, if any portion, your Lordship, if any portion has been encroached by this authority, your Lordship, be restored, be your Lordship petitioner. Your
No, my lord. At this stage, my lord.
Your Lordship, 2 bigha has already been encroached, your Lordship. Yes, Lord. 2 bigha has already been encroached.
Let the petitioner, let the authority decide. Let us see what happens. Act a line add korun. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Tarpore disposed of. Petitioners and the private respondents. Next, private respondent nahi hai. Panchayat aate hai. Panchayat, private respondent. Time of kya na bolna hai. No, jahan se oh, petitioners, only petitioners. Next. Yes. Who is appearing? Mention matter, no one. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading. Under the heading motion. In the monthly list of February 2024. Next. Monthly list of February. Mention matter, petitioner is not there. Next.
Lordship, I am appearing on behalf of the petition.
Yes.
Particulars of the villagers of village stated in para 2. the villagers of village Madhurnagar, there is a canal in plot number 3287. Khatiyan number 30.
Where is your service upon the private
I have
respondents?
This is my every service. Admit.
Well, I am appearing on behalf of the respondent number 13.
Only 13.
The complaint of the petitioner is that the private
Wait a minute, please.
Okay, Lordship.
Have you checked service?
Yes, Lordship, I am checking. Duly served upon all the respondents.
Where is the service on the private respondents?
Respondent number 5 is page 8. And into correct.
Respondent number?
Respondent number 5 is at page 8.
5.
Respondent number 5.
Respondent number 5 is not a private respondent. Private respondents are 12. Yes, 12 is served. 14. 14 and 15.
15 is 16, page number 16. Last. Respondent number 16, 15.
Page number 16 is who?
Respondent number 15.
Yes. And 14? Radhesham is not served. I do not find 734.
I will sub upon them.
Yes.
I will sub upon them again.
734?
7.
Do you have the track report with you? 734? Anyway, what is the matter about?
The matter relating to the petitions complaining that the private respondent are causing nuisance.
Private respondents?
Are creating a nuisance, creating an they are establishing an illegal poultry farm without any obtaining any license from the concerned authority, and they are converting the canal by filling up the earth. Upon the petitioner moved previously, they moved the appeal petition before the Honorable Justice Division Bench. The Honorable Division Bench passed an order directing the respondent number 2, the DM, to look into the matter, and the DM concerned forwarded a proceeding, which is as annexure P3, page 29 to 31, whereby the DM on an inquiry report, it found that page number 31, Lordship.
Yes.
Heard and pursued the report submitted by the Block Land and Land Reform Officer, the bottom second paragraph. Pathor Potima, byte number 1031, BL and BLR of Pathor 22, dated interior stating as per record, LR the Muja is classified as Khal, with a comment, Jal Nikasha Jonno Badhanor
something for 0.90 acre. A permissive position named Ramshan Pare for 0.17 acre is noted there. Reveals that from the field inquiry that a poultry farm is situated on the shoot plot. On the same plot, an education institution is
But
also.
resident villagers at large, isn't it?
Yes, Lordship.
So this is a public interest litigation.
Yes. My contention is that to comply the
You are
honorable.
not individually affected.
No, Lordship.
Then how does it lie before this court? Will you approach the appropriate bench?
Yes, Lordship, I will approach the appropriate.
Yes, please do that, isn't it?
Yes,
Because you are representing the villagers.
Yes.
Yes.
Yes, ma'am. Yes, please, madam.
Learned affidavit of service. None appears for respondent numbers 11, 12, 14 and 15. It's by service. Paragraph, it is submitted on behalf of the petitioners that they represent the local villagers at large. Paragraph, the petitioners seek to withdraw the writ application and approach the appropriate forum for redressal, appropriate bench, forum na kore bench korun, for redressal of their grievance. Paragraph, in view of the above, comma, the writ petition is released in view of lack of determination. Dismiss করা ঠিক হবে না, এটাই বলছি। In view of the above, the writ petition due to due হয়ে আছে। In view of the above, the writ petition is released due to lack of
662, my lord, I am for the petitioner, my lord.
I am for the Union of
Yes. This is my affidavit of service, my lord.
My lord, I am for the respondent number 7.
Last occasion also I have served upon the state.
Your respondent number 7?
Right.
Eta amar.
Who is appearing? NHAI, Ms. Roy is appearing. What about the state is not there as a party?
Yes, my lord.
Oh, the district.
An Union of India.
Have you served the district magistrate?
Yes, my lord, I have served, my lord. All have received.
Anyone appearing for the state? No one. Mr. Dey, may I request?
Union of India. My lord.
Mr. Dey, may I request you to appear for the state? Please give a copy of the application to Mr. Dey.
My lord, this I have no
course of the day.
extra copy, my lord.
In course of the day.
Yes.
Yes, what is the matter about?
My lord, matter is that, my lord, I have come before your lordship for unauthorized construction made over the completely government acquired land for NH 41 that was acquired, and my lord, thereafter the private respondents has made 2 buildings over that land, encroaching 5 decimals of land of government as well as their land, and encroaching my land. This is my main complaint, and my lord, I have got that information from government authority. My lord, kindly have a look into page 17 of my writ petition, my lord, annexure P1.
Yes.
There, my lord, it has been given the information under RTI that this DAG number of 395 of by 1850, 5 decimals of land were already acquired by the government for making of NH 44 for Holdia Road. And my lord, thereafter my and I have made thereafter I have made one building over 2 decimals which I have purchased, and now my lord, presently I have made complaint before the authority, concerned authority, that the private respondents are trying to encroaching my land, my lord, cover up my ingress and egress, which is government land, my lord. That is, they are making completely unauthorized. They have no
say that they have encroached upon government land
as well as my obstructing my land, ingress and egress, and now they are trying to cover up entire front portion of my land. This was the eastern southern side, But now they are trying to cover up. That is why, my lord, I have made
It is also government land, you say.
government land as well, as well as my land.
Your
Because,
land cannot be considered in a writ petition, madam. That's what I am.
my lord, government land is over that government land they have made. Thereafter, my lord, 6 links, link of, my lord, I have given 6 link of white land I have left for the village pathway. That has also been encroached. That is my case. And I have made complaint before the my lord, competent authority, and let it be considered. And
Where is your complaint?
my lord, annexed P6, 30 page 31. Last complaint. Before that also I have made 2 complaints. And itself in a shoot, my lord, they are claiming 1 decimal. Now they are claiming 6 or 7 decimal.
That is a different issue, my lord.
Different issue. I am just giving example. In a shoot, my lord, they are claiming 1 decimal. Now they are encroaching entire front portion of
Suit is pending in respect of the
that is
same
1 decimal. I am claiming that they are encroaching entire government land and as well as front portion of my land. And they have made completely unauthorized construction over that. They have no plan, nothing else. All have received all
Front
the
portion of your land cannot be considered in a writ petition. That
Well,
is
that is government land. That is government land. That is encroached. That was, my lord, kindly have a
that the land in front of your land.
That is government land. PWD land. Well,
Front
that is
portion of your land doesn't mean that, madam, isn't it?
well, ingress and egress is the my problem as well as the government.
Encroaching my land, that is your
My land as well as government land. That is ingress and egress.
Encroaching your land and blocking your egress and ingress are not the same thing. They are 2 different things. What are you actually wanting to say? They have encroached upon your land, or they are obstructing your
Obstructing my land. Obstructing my land.
So why have you stated encroaching my land?
Encroaching and as well as obstructions, my lord, both the matter is considered as.
Are they encroaching upon any portion of your land?
Yes. Yes.
They also. So what is your claims,
My lord, my claim is 6 Borgolink where I have left for the village pathway. That was, they have demanded that leave it for village pathway. Thereafter, they have encroached that. I have no claim on that. But the government land, which is covered by that 5 decimal, that was in front of mine. And they're running a shop room.
Front of your land is different from encroachment of your land.
My lord, ingress and egress is
that is one thing.
Obstruction, yes.
Obstruction is one thing. Encroachment is another thing.
Yes.
You have not stated obstruction here. You stated encroachment.
See the first prayer, my lord. Page 12, lordship. Page 12, the first prayer, my lord. Read in the nature of mandamus, commanding the respondent number 3, 5, and 6 to demolish, remove of the obstruction made by the respondent number 7, and also demolish that unauthorized construction made by encroaching valuable front portion of the petitioner's private land. Petitioner private land, how it is possible? As well as the land of National Highway Authority, my lord.
They are 2 different things.
Yes, my lord. Remove the portion which is coming under the government land. My purpose will be subserved. My ingress and egress will be removed.
The private land will not be touched upon by this report.
Yes, yes, my lord.
It will only be upon the government land.
Yes, my lord. Yes, yes, yes.
In so far as the government land is concerned.
Yes, my lord.
Yes.
Road is complete, but some portion of the road has been left by the government because RTI it is.
No, this is an allegation against the private respondent.
Yes.
They say that
This is the private dispute, my lord. No, my lord, it is not.
The petitioner says that the national highway has been encroached upon by the private respondent.
Yes, I have given that.
Let that part be disposed of. Yes.
Yes. So, lordship, from this petition does not reflect so, my lord. From this petition does not reflect.
Yes, yes. She has added her own land also. So I'll record that the private land will not be taken into consideration.
Yes, 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 my lord. My submissions, lordship, I don't know, lordship, whether the land belongs to the National Highways Authority or the PWD. If, lordship, the land belongs to National Highways, lordship, we are ready to, lordship, take all the measures, lordship, in support of the state administration. But if the land is not,
I find the representation is before the district magistrate.
Yes, district magistrate. So, my lord, And the National Highway Authority also, my lord, I have served. My lord, the appropriate authority is, my lord, here.
There is no enforcement, no abstraction of interest.
My lord.
By the private respondent residing over here last 50 years in my own plot, and that also predecessor plots. And my housing alignment as well as the petitioner housing alignment is the same. There is no question of abstraction.
The authority will decide, sir.
Yes.
And my lord, going into merits at all. But who is the authority to decide? Please tell me that.
Yes, my lord.
Is it the National Highways Authority or the
National Highway Authority? Project officer of the National Highway Authority. Respondent number 5. My lord, actually.
So let page 37 be decided only in so far as the National Highways is concerned.
Yes, my lord.
Yes, Ms. Roy, is that all right?
My lord, lordship, I have recorded without going into the merits, lordship, I have no objections on this.
I am not in any case going into the merits.
Then, my lord,
Even if, my lord, in my humble submission, my lord, even if the private respondent has made the entire building over the government's plot, that is also unauthorized construction. Without any sanction plan, let them show the sanction plan.
How are you affected, madam?
My lord, that was the ingress and that was the blocking the ingress and egress of my plot. My value of the plot will be decreased.
Clearly engineered by the.
Let the authority decide.
Our statement is contrary. My lord, please come have a look.
Period of service. You will have an opportunity of hearing, sir, before the
He
authority.
already stated that he is residing peacefully from 1999.
99, they have made this building in 2015.
I think I have heard that.
Yes.
None appears for the state respondents despite service. Please serve a copy to Mr. Dev.
Yes, my lord. By today, my lord, I am serving, my lord.
Regular school copy service direction. Paragraph. The petitioner claims to be the petitioners. Petitioner claims to be the recorded owner of the plot and of a portion of the plot. And complains that the private respondent a portion of the plot in question, and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of the national highway adjoining her property.
That is the same plot, my lord. 390.
Adjoining her property.
395 by 1850.
Thereby obstructing her egress and ingress. And also the front portion of her property. Stop. The petitioner submitted a representation before the concerned authority in this regard on. When did you submit your representation? There's no date.
My lord, yes, my lord. Thereafter, my lord, that
I'm 37.
41, my lord. Page 41, the status report started. All have been delivered, my lord. It was served 27/6/2023.
That is the delivery date, isn't it?
Delivery? No, my lord. That was the serving date, my lord.
On 27th June.
June.
Date, my lord, 27th.
7th June. 27th June. Because the receipts are there.
Stop the petitioner, place for a direction for the authority to consider the representation at the earliest. Paragraph. The allegation of the petitioner is twofold: : encroachment upon the national highway, thereby obstructing her egress and ingress, and encroachment upon her private property by the private respondent. Stop. The alleged encroachment upon the petitioner's property by the private respondent cannot be dealt with by this court in exercising jurisdiction under Article 226 of the Constitution of India.
My lord, SDO is also the competent
Insofar
authority.
as encroachment upon the national highway is concerned, the concerned authority, being the fourth respondent, herein,
No, my lord, 5 is the competent authority. the project officer of the National Highway Authority. New town. My lord, 3, 4, and 5, my lord, kindly give direction upon.
Can be direct, only one
Because-
person can be directed.
Yes, my
Terms of this representation, my lord,
It's
the
project
respondent number
officer.
5, my lord.
5.
5, my lord.
Give on.
And my lord, 3 also, subdivisional officer, because demolition order will be
The-
given by the subdivisional officer.
The fifth respondent. The fifth respondent is directed to the concerned authority, being the fifth respondent herein, comma. Fifth respondent herein, comma, is directed to consider and dispose of the representation submitted by the petitioner in so far as the alleged encroachment upon the national highway is concerned, comma, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law.
My lord, without going into the merits, my lord, kindly, my lord. My lord, kindly, my lord. Otherwise, my lord, because
Please show me one line where I've gone into merits.
my lord,
And my lord, respondent number 3 also.
That's all.
my lord, that will suffice.
My lord, respondent number 3 also be given a direction.
Fight with
No, my lord.
It is possible. to-
After if after that unauthorized construction be detected, thereafter section 10 will be order will be passed by the DM or subdivisional officer.
10 will not be applicable in this case. This is
case,
not related to
national
the road.
highway
It's
plan was
national highway.
possible.
Then my lord,
Whatever has to be done will be done by the fourth
yes, my lord. Yes, yes. Then my lord, if my lord one line be added, if unauthorized construction detected, then demolition proceeding will be started.
Even without adding that line, sir, the authority will
Yes,
take
ma'am.
decision. Will take
Yes,
decision.
ma'am.
My lord,
Yes.
yes, also pending before the trial court regarding the ROR.
That is for 1 decimal, my lord.
That's a different issue altogether. This
Yes.
is national highways.
Yes.
That's why I've stated that the private property will not be taken into
Yes.
consideration.
It is his own declaration
In
should.
respect of the national highway that the authority will decide.
Yes.
My lord, may I be permitted
This
to
was
mention, my lord? May I be permitted to mention, my lord? Regarding item
This
number,
is not the mentioning time, sir. I'm
my
sorry.
lord,
Please come back at
the
10:30
matter
tomorrow.
is running in the list, my lord, mentioned matter.
Maybe.
But
Please come back tomorrow.
there is a certain probability that the matter will be called on today, tomorrow, my lord. Tomorrow is some difficulty to appear, my lord. Let it be day after tomorrow.
I cannot do that, sir. Let it be called. Let us.
Lordship, I am for the petitioner, my lord.
Yes.
Lordship, this is a matter, Lordship will remember, my lord, pertains to platform loading. And Lordship has passed an order on 5th of April 2023. Lordship, kindly see Lordship's order. Lordship, upon adopting the division bench's order, has directed the petition to go out of interim measure, directed to go out of list. My lord, it appeared wrongly before another bench, my lord. I got the same released. So, my lord, at present, the issue is pending before the division bench. Let the issue gets clarified over there. Subject to what my learned friend says.
The matter was out of list.
Out of list, my lord, but wrongly it appeared in some other bench. It was detected, and then and there it was mentioned, and I got it released. Now it has appeared before your lordship. Lordship will see it, lordship. Let it be.
In terms of the order.
Yes. Subject to what my learned friends.
Yes. In view of the observation made by this court in the order passed on 5th April 2023, let the matter go out of list with liberty to mention. Next.
No. My lord. My lord, 742 and 743, on behalf of the petitioner, Mr. Satik Bhattacharya is my senior. He's on his legs, my lord. Kindly give me a short password.
Passover is not possible in this court. You're aware.
Oh,
by
sorry.
now. Debro is appearing.
কোনটা গেছে আদা সত্যি
Yes. Your application was before the application of the private respondent.
Yes. But fact remains in this matter, my lord.
Seven, 48, 49.
Let him prove that the tackling has been cancelled. Let him prove fast. Let him prove it. It should be on record. But let it be proved, let it be shown, my lord, first, that my offer letter has been cancelled. And extension of.
Have you submitted a report? Because if since you say that the earlier application was rejected for not placing the vehicle within the stipulated time frame, and after that the vacancy is filled up by the private. And what about the second application? When was that made? The vacancy was filled up prior to submission of this application. The second application. Let the petitioner show the relevant documents.
Yes, my lord.
Yes. Actually, it is not required. Yes, Mr. Bhattacharya.
My past application, my lord, page 31. Your lordship kindly have it
kindly have a note that my application number is last 884, page 31.
Yes.
Route is, my lord, Siliguri to Ranchi. My lord, page 33.
Yes.
My lord, I have submitted the permit fees, page 34. This is in respect of first application. Now, my lord, second application is page 36.
Where is the offer letter?
Yeah, sorry,
Respect of the first
I'm
application.
coming. But these are the two applications, my lord, page 31 and 37.
Yes.
37.
Yes.
In respect of single vacancy. But at that point of time, two vacancies were there. My lord, it has been taken into consideration by the authority in its board meeting, page 43, is the inviting letter, and my lord, offer letter, my lord, decision, my lord, page 49. Decision, my lord, page 49. My lord, I am reading, my lord. One application from Nilkamal Sohai was approved in ST voting dated by Regent number 45, but he did not apply for permit. He has been called on to clarify the reason for not obtaining permit. Nilkamal Sohai was absent on call despite receiving the hearing notice, but he submitted one representation for foregoing his claim for permit as per docket number 41, which was placed before ST in its meeting dated 29 June 2018 by Regent number 45. My lord, my application, my lord, in 2022. Now, my lord, this representation of Nilkamal Sohai seems to be faulty and suspicious since member of the estate decided
Nilkamal
to.
Sohai is neither the.
No, my lord, he forward his claim, my lord.
Yes.
Next page 50. Adda Shakti Transport Kumar, two application pending for consideration, two application. My lord, member operative person, my lord, Mr. Sri Bhudev Chandra, Mrs. Adda Shakti Transport Company were present. He could not produce the possession of vehicle registered in his name. Members of STA also decided that application number dated 21/6/2022 is considered as approved subject to payment of all requisite fees. But my one application has been approved out of two applications. Page 50. 31 is only approved, 37 is not approved.
Yes.
31 is approved, 37 is not approved. Another thing, my lord.
But 31, you were supposed to place your vehicle within 30 days of the offer letter.
Yes, my lord.
Where is that document?
That document, my lord. My lord, page 55. The offer letter is attachment to page 55. I have paid for extension of validity of offer letter. Because, my lord, an offer letter is to be extended till for a period of 6 months. But end this matter, my lord, I offer letter obtained on 18th October 2022. I have already chassis the vehicle to place it in the offer letter for obtaining permit. Some time is required to build the body. I have already obtained chassis. Sometimes it is required to build the body shell as such. My offer letter validity extension for 5 months. I am enclosing having the original offer letters and challan number such and such 2540 and other documents for your kind result. This letter was issued on 7th November 2022. No response. No response. No response, my lord. On the other hand, I have been directed to apply a phase, page 54.
54?
58. As per their direction, oral direction, I have to apply. I had to apply. Now, my lord, your lordship kindly come to.
This is the second application.
This is the third application. Because second application, no consideration has been made. In its decision, my lord, page 49. But your lordship kindly page 50. Two applications is there, means has been mentioned. Page 50, my lord, your lordship kindly come and look at page 50.
Correct.
Two applications is there. Consideration only one application. No whisper about the second application.
There was one vacancy, page 50.
My lord, and declare one vacancy against the application of Nilkamal Sohai. But no consideration has been made in respect of a second application. However, my lord, your lordship kindly come to the page 63.
53.
63. After making my application afresh on 58. My lord, 63, no consideration has been made in respect of my application for extension of offer letter. Thereafter, I made an application, my lord, page 63, 8 June 2023. My lord, in this letter, my lord, I have submitted all the documents relating to my vehicles.
This is with regard to the first
Grant. First grant. Everything has been submitted, my lord.
Yes.
My vehicle number is ready now. So
After this,
after this, my lord, the include order, my lord, page 67. No, my lord, this is not my lord, sorry. But entire documents I have filed, I have submitted, my lord, up to page 70, page 78, my lord.
Page 64 is the offer letter.
Yes, my lord. Up to, my lord, along with my application, my lord, dated 8 June 2023, annexure P5, page 63. I submitted all the documents relating to the permit, my lord, up to page 76. Up to page 76. All the documents have been placed with a representation, that representation till date not considered. Now, my lord, thereafter, my lord, since my lord, I had to apply, I have been constant to apply a phase, my lord, on annexure page 58, my lord. This application was taken into consideration further, my lord, on page 77.
'77 is a notice.
Notice, my lord, for inviting the applicant for hearing. My lord, I appeared 79. My lord, I made a representation that my earlier representation dated 7th November 2022 for issuance of permit in terms of the offer letter has not yet been disposed. Page 80. Page 80, my lord, before that, my lord, the hearing was took place on 18th August. And my lord, on that very day, my lord, I made a representation this day. Despite this, my lord, no consideration has been made. On the other hand, the improved decision has been passed, allowing the added respondent, my lord, today he also did not turn up despite notice. Improved order after filing this application, improved order was passed, that is in my supplementary affidavit.
That page.
Page 12. Against the non-consideration of my representation, my lord, I filed the writ application. It is admitted position that the members of the estate did not decide by mistake reject the another application of Mr. Adasukti Transport Company. When, my lord, after making payment of prescribed fees for grant of permit, one application is being made by an intending operator in terms of Section 80 of the Motor Vehicles Act. My lord, that application ought to have been considered either by rejecting or by allowing, as per Section 80, my lord. But in this case, that has not been done. Last line of page 12, my lord.
No, they have admitted that they have accepted one application, the first one.
But my lord, so far my second application is considered that one line order ought to have been passed, that since there is no vacancy, my lord, your second application is rejected. When I have paid fee, And without considering my prayer, my lord,
You have one vehicle.
yes.
Yes, the first application is 884 in respect of one vehicle. In the next applications, the subsequent applications, you place separate vehicles.
Separate vehicle.
But admittedly, there was only one vacancy.
Admittedly, there is one vacancy as on, my lord, 18th August 2023. How this vacancy occurred, my lord? Since my grant of permit has still in abeyance, my lord, in issuing permit. I have been granted permit in respect of one vacancy. I have submitted my vehicles in terms of the offer letter. That application has not yet been considered till date without rejecting my prayer for issuance of the permit in terms of the offer letter. How could vacancy arise, my lord?
Vacancy arose in respect of that other Neil Komal or whatever that
No,
was.
that vacancy has been filled up by granting permit in my favor. That vacancy has been filled up.
So there should not be any other vacancy.
There should not be any other vacancy since, my lord, my representation for issuance of the permit in terms of the offer letter has still been, my lord, under consideration.
Yes, let Mr. Debra respond to this.
And my lord, so far coordinate bunch of this order, my lord, when the in terms of the registration of offer letter, vehicle has been submitted, that offer letter cannot be cancelled. I have a judgment of this.
Has not been cancelled.
No cancel, no order has been assigned.
The order impugned also, they say that they have allowed your first
Yes,
application.
madam. No consideration, no order, nothing.
The subsequent applications have been rejected since there was no vacancy. It is a fact.
It is a fact.
Yes.
But how that vacancy would arise? When I am in line.
Where is the document showing that the private respondent has been granted permit?
This is the page 12. Page 12, page 13, my lord. Page 13. Approval has been made by lord, page 12. At the top. One quota was vacant for the institute. Members of the STA board considered and allowed the earlier application of Mrs. HON'BLE Poribor Private Limited. And more peculiar thing, my lord, in the vacancy list, my lord, there was no vacancy. 30th June 2023 vacancy list was published. In that vacancy list, there was no vacancy in respect of the route Siliguri to Ranchi. Since that vacancy has been filled up by the offer letter in my favor.
Yes, Mr. Debra, there appears to be some anomaly. Yes.
At the time of taking up this matter, there are three applications, two applications.
Three applications were there.
These applications there after something two applications.
Initially.
Immediately after something what
Yes. There was only one vacancy. Adda Shakti got that vacancy.
September 2020.
Yes.
18th October 2020, this is the letter of the offer. Then my lord, of the motor vehicle, at least they have to produce or submit any papers or documents regarding the vehicle problem within a month. Thereafter, they never
they specified.
Then, they are after June 2023, they are approached the authority and submitting all the documents.
But there was a prayer for extension before that.
Therefore, extension is there within the 60, within the 30 days, they have not produced anything. 141. June 141.
Please come to the order impugned. Admittedly, there was one vacancy. The order impugned says. No, in the order impugned, by the order impugned also, you have allowed his first application. So after that, there is no vacancy. How could you allot to this other, the private respondent?
Next week. Next week.
Where is the vacancy?
After rejection, the application, then
His application is not rejected. You have allowed. Please come to page 12. The second application was rejected, not the first application. The instruction says, since the petitioner failed to apply for permit within the permissible valid period, one vacancy was created. Where is the rejection? Vacancy should be upon rejection. Where is the rejection? It is not rejected. There is not one line showing that it was rejected. The later application was rejected, not the first one.
Second application.
989 was rejected. The first application was considered as approved. Yes.
And after month of the valid period of operator of permit is thus failed to apply for permit within the permissible period.
Where is the rejection?
It is automatically rejected, my lord.
There cannot be automatic. Cannot there be automatic rejection?
In this code, my lord,
Central rules. Central rules. State rules. State rule. State rules. The vehicles rules.
এখন বই রয়েছে তো রয়েছে বই রয়েছে
আচ্ছা The proviso. So there is a prayer for extension. Where is that prayer disposed of?
Within the time.
There is a prayer for extension.
Yes.
Within the 1 month.
Yes.
It's page 55. Where is the letter seeking extension?
Offer letter dated 18th October. Specific offer letter dated 18th October. I applied 7th October. 8th October, 18th October. 18th October. I applied 7th October. Extension.
Where is the extension letter?
Page 55.
55 is not the extension.
Application.
Oh, some time is required, yes.
Application, ma'am.
Yes.
These have not been considered.
Without considering this, a fresh, and there is no rejection also. And it is not stated that it can be automatically rejected. Rule 141 doesn't say so.
Similar point. 141, rule 141, application was made for extension. That was not considered and impliedly rejected. Issuance of the fund is refused. Vehicle has been produced in terms of the offer letter. That could be taken into consideration as per order.
Yeah, you have not produced the vehicle.
Yes, sir, I have produced vehicle.
Within the time.
I have produced the vehicle.
There was
Within the time.
Mr. Debra, there was an prayer for extension. You have that has.
I have already.
People have already produced or not?
Yes.
Who? I have already sent the vehicle to place it in the offer letter for obtaining permit. Sometimes we request to bring the body. Immediately after body,
these applications are not considered. That is better. Then also pass the resolution. I will not.
Even if my lord, this order, pursuant to this order, I am entitled to get the permit.
Yes, the order include also says that the first application was approved. The second application was rejected. So upon if the
But that like explain on the offer letter. What action? What action was taken? That is what.
no, even the last order says approval.
Last order. Where does not declare this, whether it is declared. Yes, sir. I only say whether they are for extension or pay, whether it is
Well, here this clear indication of page 12. My lord, can you have a look again? Page 12.
I've seen page 12.
My lord,
Page 12 of the supplementary affidavit.
he may apply this the data after about petition for extension of letter with validity for the extension. SPA may allow such extension up to 180 days from the initial date of issuance of offer letter. If no such application received within the stipulated period as mentioned in Rule 141, the offer letter would be treated as cancelled without notice to the applicant.
Yes, yes, I've seen this.
Another point I have mentioned, my lord, in the improved decision, the consideration of the application has not been made in accordance with law upon assessing the comparative chart, because on that very point of time, I was possessed with the vehicle, but the applicant grantee into alleged grantee has not been possessed with it. If no vehicle is possessed by anybody, it cannot be offered for grant of permit. That point has also been taken, and in my repetition, in support to that contention, I have submitted the order passed by this court in bench of this honorable court, page 85. How the application would be assessed and considered, page 85 of my application. Let them also take instruction in this point also. Whether the application of the added respondent has been considered in accordance with law or not.
No, no. The grievance of the petitioner is twofold. Stop. Offer letter with regard to the single vacancy in the route in question was issued in favor of the private respondent subsequently by the authority, though the earlier, though the offer letter issued in favor of the petitioner pursuant to an application submitted by him earlier was not turned down. Stop. In fact, comma, even in the order impugned, dated, even in the resolution impugned, dated 18th August 2023, comma, the authority has held that the members of STA decided to consider the earlier application of the petitioner as approved, and the second application was rejected. Stop. Since there was only one vacancy in the route in question, comma, the concerned authority could not have issued the subsequent offer letter in favor of the private respondent during pendency of the application filed by the petitioner for extension of time to place the vehicle, and also, comma, since the application filed by the petitioner was not turned down. Paragraph. Secondly,
I have already placed the vehicle. Also, subsequently.
ওখানে একটা line add করুন। The petitioner has already placed his vehicle before the authority.
Page 80, madam. After 180 days. Page 80. But this 180 days to be.
Page 80 is your representation.
Yes, ma'am. Sorry, madam, sorry. Madam, page. Madam, page madam 63. 63 to 77. 76. 63 to 76. Already placed vehicle. 8 June 2023. Offer letter was issued October 2022.
Extension was not turned down.
That is another aspect. Now what?
That is the main aspect.
That is why madam document record my.
He submitted the extension letter within time.
Extension letter. Report vehicle. Here, secondly, the report is there. Produce the vehicle within time.
No, no, he has not stated that for once. He has produced the vehicle, Mr. Debra. কি বললাম? The petitioner has already. দেখে নেন। Petitioners, along with all relevant documents, stop. Second paragraph. Secondly, comma, the application filed by the private respondent was not dealt with by the authority in accordance with law, since the private respondent did not place vehicle.
No vehicle has been put.
Submission. This is the submission, yes.
And another thing.
Since no vehicle was placed by the private respondent before the authority at the time of issuance of offer letter.
Page 14 of the supplementary. Page 14 of the supplementary. But there was no vacancy. As on 30 June 2020.
Also, comma, there was no vacancy in the route in question as on 30th June 2023, when the application filed by the private respondent was taken into consideration. Paragraph Learned counsel for the state respondents submits that the vehicle was not placed by the petitioner within the stipulated time frame and the time frame for which the application filed by the petitioner was rejected by the authority. Stop. Learned counsel seeks to take further instructions in this regard. Paragraph, let the matter appear under the same heading on Mr. Devra, when can you come? It will be taken up. On the next day, I'll take up all the points together.
Page 17 of my supplementary evidence. Against the private respondents, there is a complaint of a 77 crore scam. Page 21, the Samoli Poriman is involved in that scam. Without considering this minor fees application, he should not reserve any part.
In any case, let us decide. On 16th February. Beautiful. Yes. Yes. 18th is a Sunday. 19th. 19th February. Next. Yes.
Despite vacancy, my lord, in this matter, my lord, I have not been granted permit.
Who is it? Mr. Devra? Yes.
Despite vacancy, my lord, I have not been granted permit on the sole ground that there is a vacancy. And report, my lord, has been called for by this one.
Yes, Mr. Devra, how do you explain this anomaly, this discrepancy? In the vacancy list, one vacancy is shown, but you have rejected on the ground that there is no vacancy. How do you explain this?
Page 4, paragraph 10.
One vacancy was offered, one party was surrendered.
You say it is a mistake. What is the current position? Has the permit of Srimati Nomita Chatterjee been cancelled?
Lordship kindly call for the report, my lord. When his application, when the permit of the Nomita Chatterjee has been cancelled.
Here it has not been cancelled as yet.
Yes, but
it is under consideration.
But approved, page 4, paragraph 10.
Yes.
Last 4 line. The application for cancellation shall not be still not been approved, and such cancellation was approved by the STA board only on 23rd August 2023.
And you filed the application prior to that.
Prior to that. And my lord, on 18th August, my application was rejected. On 18th August, you lost the date.
18th August, there was no vacancy.
Making sure there, my lord, because that application of the party of the Nomita Charity has been cancelled. Prior to that,
Was cancelled on 23rd August.
no, my lord, this is needs to be verified by from the record, my lord. But it since it has been cancelled,
Mr. Devra, you have not annexed any document to your report?
after the cancellation of his party, the package share.
The relevant documents. So please take back your not affidavit. The relevant documents should be annexed. When his application was received, when the earlier permit was cancelled, those documents.
23rd August 2023. There is no board meeting on 23rd August 2023.
So please take this back. It is federal deed.
On 18th August, my lord, board meeting was.
Let the state come back with a comprehensive report with the documents, Mr. Devra. Annexing the documents of application, of rejection, all the documents. Learned counsel for the respondents seeks further extension of time to submit a report in the form of affidavit, annexing relevant documents with regard to cancellation.
Of PSTP number 03.
Let it be all relevant documents, because if I mention one document, only that will come before the court. All the relevant documents should come before the court. Yes. Paragraph, let the matter appear under the same date, 19th.
And my lord, in order, my lord,
On 19th. It is already till further orders. It's a blanket order. Huh? All the relevant documents.
We did also fix on 19th.
19th, yes. Next.
The vehicle is flying without finding on for a report, my lord. My learned servant, my lord, he wants to file something there. Serve your copy, my lord. Filing one for a report, my lord, I am suffering from long. This matter was moved to the future vacation, my lord. Vacation time. I am grateful to your lord for the matter of filing.
Who is appearing for the state?
For
the yes, Mr. Mitra is appearing for the state.
Yes, ma'am. I have been granted permit. Initially, it was approved for 1 month. I applied for extension of timetable, and that approval was made after seeking objection from the inviting of.
You are the petitioner.
I am for the respondent for.
Oh.
He's a private respondent.
Well, I have been granted permit. I have been granted permanent permit.
He's flying the vehicle without any timetable, my lord. That is the
Maybe because
I
of the,
do not find the state today who is the answering
because of
respondent.
the pendency of the declaration, my timetable has not been renewed.
He's flying the vehicle.
Is it the intention? My grant will be there. I will not be up. Permit has been granted for operation of vehicle.
From whom?
From the MBI, my lord. He's in league with the official respondent, my lord. They are taking.
I have been.
Supplementary affidavit submitted on behalf of the petitioner is taken on record. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 9th February. Please inform the state.
On the 5th, my lord, today, sir. On the 5th, my lord, I am suffering. This matter was decided before the puja vacation, and that matter is not appearing.
There is little difference between 5th and 9th. Why are you bargaining with date?
So I will inform today, my lord. You can go to the grateful, my lord.
Writ petition. Supplementary respondent dite পারে না। Writ petitioner আছে। তাই তো লেখা আছে ওটা। ওটাতে writ petitioner লেখা আছে, supplementary affidavit দিন। Supplementary affidavit। তাই দেখে হল। Next.
I am for the petition.
Yes.
No, Lordship, that is the connection. No, connection of the state, Lordship. Connection of the state transport, Lordship.
After all, this matter was dismissed on the last
Last
for default.
Lordship, I mentioned before the court that matter is Yeah, mention.
They should inform me.
Oh my
the
God.
matter is appearing today or it has been restored.
You are appearing for whom?
Lordship, the matter is connection for district transport, Lordship.
My client.
What is the?
Lordship, Lordship, main allegation, my allegation and main
Yes, sir.
matter is based on the agreement, Lordship.
Issued by me. I am the special officer, who is responding number 5, Your Lordship, of a cooperative society, Your Lordship. This is a dispute between a person having transaction with a cooperative society, Your Lordship. So possibly this is a group 5 matter.
No, Lordship, main matter, Lordship, ferryguard is allotted Lordship, 1 minute, Lordship. Lordship, this matter, Lordship, first, Lordship, the petitioner had operated the ferryguard since long time back. Due to 1996, the state government, state of transport department allow a new route, Lordship. Thereafter, after issuing a new route, the Hooghly Nodi Jalapad Parivahan Sabha made an objection. Then government was interfered this matter. He says that the petitioner, if the petitioner is use my vehicles, that's vehicles, they allow, Lordship. Thereafter, the state government interfered this matter. Matter is solved, and Lordship, 1996 agreement was made. The agreement, the matter is only based of the agreement, Lordship.
Agreement between whom?
Agreement Hooghly Nodi Jalapad সংস্থা and petitioner, Lordship. সমাবেশ জলপথ পরিবহন সমাবেশ সমিতি and the petitioner, Lordship. But my challenge, Lordship, as per agreement, the special officer have power to take a decision as per agreement, Lordship. Agreement totally says that the decision taken by the chairman.
Court of determination.
Lordship, this is matter is related.
Subject to payment of the port due.
No,
I am not
no,
on
I am
merits
fine.
at all. I am not on merits at all. How does this court of determination?
Lordship, the matter is interfered with the state government on the
It is
basis of
with
the
regard to
letter.
the cooperative society?
Lordship, cooperative society.
Then
Or residuary.
it will appear before the appropriate bench.
Lordship, kindly release this matter.
It is submitted on behalf of the parties that the matter pertains to group 5 of the classification list.
Say,
Paragraph-
as per group 9.
Matter be released due to lack of determination. Next.
No. Lordship.
For the petition in this matter, Lordship. On the last occasion, on 19 December, there was a direction to take the instruction. The state government is required to take the instruction in terms of your Lordship's order. So my fundamental grievance is this, that the several autos are playing in the route allotted to the members of the petitioners union without valid permit, thereby affecting the business of the petitioners prejudicially. The petitioner submitted a representation in this regard before the concerned authority and prays for consideration of the same at the earliest. Now, there was a submission which was recorded. As per the submission, almost as many as 56 autos have been prosecuted. Now, Lordship, my specific instruction is this. Lordship, they may be directed to produce the documents regarding whether they have been prosecuted or not. Now, for the time being, Lordship, that will suffice because we are already having the permits. But the concern is that route.
The authority is taking steps.
The authority, whether they have taken steps or not, that's why the instructions are required. This is very important, Lordship, because otherwise, Lordship, Lordship, we have the right because of the thing that because of the illegal act and non-action of the authority, we are prejudicially suffering. So we have a right.
Will you serve a copy to the petitioners?
I'll go through this and come back.
See if you can go through it here and now.
পোস্টম্যানের মতো গেট করে চলে যাচ্ছে তারপরে পোস্টম্যানের মতো অর্ডার দিয়ে দিচ্ছে কিছুই হচ্ছে তোমারও কালকে আসতে পারে
Nothing further remains for adjudication.
I have not received, Lordship. That's the only. He doesn't have a copy today. Kindly keep it tomorrow, Lordship.
The same report. No, the same report has been submitted. This is the same report. এটা ফেরত দিন। The same report, yes. It was submitted in the earlier date.
We have not received the copy, Lordship. That is the difficulty. So may I just go through and take the instruction, Lordship? Kindly give it.
It is submitted on behalf of the respondents that the authority has taken all necessary measures for curbing, CURBING, curbing plying of illegal auto rickshaws in the route in question. Paragraph, learned counsel for the petitioner seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 20th.
Lordship, kindly also direct them to take an instruction regarding the autos which are unauthorizedly being operated on that route. That was kindly see. This is that as per the order of the Honorable High Court that the particulars of offending autos are as follows.
These are the autos.
How? So these are also running. That is the problem. I will also take the instruction.
Next.
This is the report, Lordship, can you see all complete?
I have seen that.
That's great for that.
But I am for the peace.
Yes.
In earlier occasion, my lord. In earlier occasion, I gave leave to file supplementary affidavit.
Who is appearing for the respondents? Jharkhand. Yes. Yes, you've received a copy. State of West Bengal, no one. Mr. Devra, may I request you to appear? Jharkhand is having some difficulty.
Yes, ma'am.
Please come back.
Next week, my lord,
Let me see.
it can be
Supplementary affidavit.
conditioned.
Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph. Where is the affidavit of service?
Not have already.
This is supplementary affidavit. Oh, this is affidavit of service. None appears on behalf of the state respondents, respite service. Paragraph, Mr. Debra, appointment regular, who is present in court and represents the state. Along with junior clothing. Please serve a copy of the petition to Mr. Paragraph on prayer of respondent number 6, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 7th February. Very good. 9th. Next.
Shall for the writ petitioner, my lord. Lordship, this is I'm বলেনি Lordship, একটু মনে করিয়ে দিন।
Service recording.
Yes. Of my lord's order, God, I am filing the report in the form of evidence.
Have you received a copy?
My lord, today they have served me just right now. My lord, probably
Copy is here.
may I say, my lord, the brief recapitulation of the facts. It's a very short issue is involved. Petitioner is a registered leaseholder with the railways. Now, my lord, petitioner
being eligible, participated in one e-auction. Now, my lord, the procedure is set out in the FM Circular 11 and 12 of 2022, which says that the system, in the system particularly, we have to upload all the papers as asked by the auction authority, and only upon submission of those, they will allow me to register my bid. Now, my lord, here is the case is this: petitioner has participated in the e-action.
I think
And-
without submission, it will not be registered at all, isn't it?
Yes. Now, my lord, clause 1.4 is very clear. Lordship will kindly has remembers.
I have, I think,
Yes.
repeated the facts in the.
Yes, yes. My lord, only one thing I want to highlight, only two things. Page 30 is very relevant. Because this is the clause which they are relying upon. It says, may I read, my lord, clause 1.2 for once?
Page.
Page 30 of the writ petition.
Yes.
The entity shall be required to upload the audited balance sheets and PL account statements of the last 3 financial years in their profile in IREPS before start of the bidding in the auction in which they want to participate. Railway shall verify the audited balance sheet and PL account statement uploaded in the profile in IREPS of the successful contractors anytime after the acceptance of the bid or during currency of the contract, and if the information about the financial eligibility is found to be false, misleading, or the document uploaded by the firm are found to be false, invalid, then the allotment of the lot shall be cancelled, or if the contract has been issued, the same shall be terminated, forfeiting the EMD security deposit without any further notice. Now, my lord, second clause 1.3. If the audited balance sheet and PL and account statement of all the 3 preceding financial years are not available, then the documents of the year for which the same are available shall be uploaded, and the same will be taken into consideration for judging the eligibility of the bidder. Now, this clause is very vital, my lord. If the turnover details are not entered by a registered entity in the IREPS profile, the system will not allow the entity to participate in auctions for lots for which the minimum turnover is required and greater than 0. Now, my lord, my case is this: I have uploaded all the documents. Now, only upon uploading the document, the system will allow me to register my bid. The bid has been registered in my name, which is at page 26A. Now, thereafter, my lord, after 1 month of generation of the bid, they have issued one letter, which is impugned here, my lord, as page 27. Would you kindly see? I will not trouble your lordship with the entire or only the last 2 paragraphs. In compliance to the page 27, annexure P3. In compliance to the above provision, the participating entity is required, kindly see the wordings, is required to upload the PL and L account statement in support of their annual business turnover positively. But you have failed to upload a valid document, visually P and L account, which tantamounts to negligence. Kindly mark the word negligence in the bidding procedures, as the only eligibility criteria is not supported by proper documents. A competent railway authority, finding no other option, has decided to cancel your bid in the e-auction and to forfeit the amount of earnest money in terms of para 2.2 of standard conditions of
The
contract.
report says otherwise.
The report says they have added 2 things here. Now, which is not present here, my lord? Kindly see the report, paragraph 11. Paragraph 11 says that during scrutiny of bid of the highest bidder, Mrs. Anjali Shivam Cargo of Janta Adarsh Vidyalaya, Howrah, by the auction conducting officer, it was revealed that the turnover of the financial year 2020-21 as declared by the bidder in the column turnover data entered by the bidder of the bid sheet was 64,32,450. But the supporting documents uploaded by the bidder was for 23,64,800, which is contradictory and not complying the turnover requirement for the specific bid in e-auction module, which was rupees 50 lakhs. As such, his bid was disqualified as the only eligibility criteria is not supported by proper documents. Now, my lord, the impugned notice is not saying that I have not uploaded anything. He is saying that I have not uploaded not a single document in support of my what I have contended. It is not saying that I have uploaded only 23,64,000. I have not uploaded any turnover details in support of 64 lakhs. Kindly see the wordings. They have tried to justify this, my lord. This is an act of afterthought. Because the reason, my lord, kindly see my annual balance sheet for once. Annual balance sheet I have enclosed at page 66 of that particular year.
Yes.
Page 66, relevant page is at page 72. 72. Kindly see.
Yes.
This is from this chartered accountant, my lord, which I submits. I do hereby certify that the turnover of Mrs. Anjali Shivam Cargo is 64 lakhs. Now, my lord, first they have said that I have not submitted anything. This is an act of negligence. Now they are saying in the report, my lord, after the hearing took place, lordship has expressed his opinion. Now they are trying to cover it up by saying that I have misdeclared. Now, what I could have misdeclared? The report is there with me. The chartered accountant's profit and loss account is also there with me. Lordship, kindly come to page 70.
Mr. Let the authority explain.
They, Lordship, they have said in their report also, my lord, kindly come to page 5. In the report also, their statement is fortifying my case. Page 5, Roman 2, my lord.
Yes.
Once the intending bidder has successfully registered himself in the IRPS portal, and after making payment of one-time registration fees, he shall be free to participate in any auction conducted through e-auction leasing module of IRPS. For participation in any specific lot asset in e-auction, he has to fulfill the required criteria of annual turnover for the asset being bidded for.
This is the rule.
This is the rule. Until unless I if I do not possess, I will not waste my 7,40,000. I know fully well that the system will lock it and say that it's a misdeclared or you have not fulfilled the criteria. I say I have fulfilled my criteria and they have blamed the system. Kindly see that in such situation, the module takes this declaration as false declaration. They have not applied their mind.
And you have challenged the 6th September notice, isn't it?
Yes, I have challenged the disqualification of the bid. My point is very clear. Until and unless I do possess the relevant criteria, my lord, they will not allow me to register my bid. That is what not I am saying. That is the rule saying. That is their report saying. And they said that I have not uploaded anything in the impugned letter. Now they say that I have misdeclared. They have not stated that I have misdeclared in the impugned letter, which is at present assailed before your lordship. Kindly see page 27. The reasoning there, the reasoning here.
Yes.
Lordship, kindly see my reading.
Yeah?
Report, Lord.
Yes.
Lordship, paragraph 3. The e-auction for 3.9 based on FSA RI of Utila Express Howrah was uploaded at IREPS Railway E-Procurement System, right of which e-auction was scheduled on 17th August 27. Commencement date of contract period was scheduled on 29th October. Paragraph 4. That as per the standard condition of contract award in e-auction, which is the guiding policy of all e-auctions for commercial army. Non-fair revenue and other army leasing contracts awarded to e-auction. All prospective bidders will be required to get themselves registered in IREFS. Paragraph 5. The bidders intending to participate in the auction should register themselves in IREFS auction leasing module and participate in auction by submitting their bids on www.website on the auction date and time. That right clause 1(4) of their standard conditions.
These are the rules which we have gone through several times.
First 1.4.
Please come to your letter disqualifying the bid.
Yes,
what ground have you taken?
Lordship, kindly see what's the ground below. Paragraph 11 below.
The last paragraph.
Paragraph 11, but that during scrutiny of the bid of the highest bidder, By the auction conducting officer, it was revealed that the turnover for the financial year 2021, as declared by the bidder in the column turnover data entered by the bidder of the bid sheet, was to be 64,32,450. But the supporting documents uploaded by the bidder was for 23,64,018, which is contradictory and not complying the turnover requirement for the specific bid in the auction mobile, which was rupees 50 lakh. As such, his bid was disqualified as the only eligibility criteria is not supported by proper documents. Not that there is two stages. One stage is registering, and the second stage is not bidder. So, in the bids, you should follow the. You should follow the.
Your turnover requirement is 50 lakhs.
50 lakhs.
Please come to page 72.
But you
72 of the writ petition.
documents uploaded only 23,64,080.
Cannot be.
Where is the document? Have you annexed it to your? You have not annexed it to your report.
I have annexed all
This is
every
the
document.
document uploaded which shows 64 lakhs and odd.
Page 70 also, my lord. Page 70,
These are
page
the documents uploaded.
of that year, my lord.
Yes.
It's not of 22 or 23. It's of that year.
1st March
Yes.
2021.
Only the Lord, registering eligibility is not condition. At least we have two stage of the condition. One is stage is bidder condition. He stated 64,32,450, but he submitted the documents of only 23,64,000.
This is the document submitted by him. You have not annexed any document in support of your contention.
Not to kindly see the paragraph 9, Not to kindly see paragraph 9,
Of
my evidence.
Yes.
Why it clause 1?
These are only letters. Where are the documents? Paragraph 9 talks about the rules.
And rules.
Admitted. There is no dispute.
And that rule Roman 2 justifies my case.
I will not see that clause. No, this is the rule below.
You have stated the rules in your report, sir. That will, you have not abided by the rules. The rules are all very clear.
So, your lordship, kindly see the clause 1. This is the documents below. That by clause 1 of the above mentioned guideline, it is clearly stated that all contractors who intend to participate in the auction conducted through the auction leasing model of IRES to fulfill certain requirements before they can submit their bids. These mandatory requirements are detailed below. Well, is relevant below 6. Updation of turnover details.
Yes, that the petitioner has submitted according to the petitioner's documents.
But no. Second,
Then in that case, I wouldn't have been allowed to take part in the bid. My bid wouldn't have been registered even.
Paragraph 10, that for such auction participation in IRES, it is 2 stages process followed by the intending bidder. First stage, the intending bidder has to register himself in IRES order so as to participate in bidding or registration. He has to fulfill certain requirement as given in the site. Second, once the intending bidder was successfully registered himself in IRES portal, and after making payment of one-time registration fees, he shall be free to participate in any e-auction conducted through e-auction leasing model of IRES. For participation in any specific plot asset e-auction, he has to put the required criteria of annual turnover for the asset being bid for. So, your annual turnover, you leave the.
Kindly come to paragraph 1.
I'll have to find 6 page 72 below.
Page
page 72 of their petition.
Yes.
Who will be concerned, I do hereby certify that turnover of so and so is rupees 64,32,000 during the financial year 2020-21 has been reflected in the provision loss account drawn by him for the year 31st March 21.
Yes.
Along with balance sheet, and also kindly see page 71 minute.
Yes.
Only of rupees 20.
This is the profit and loss account. It is profit and loss account at page 70.
This is the balance sheet.
The profit and loss account.
They have shown.
Page 70 is a profit and loss account, which they are saying I have not submitted.
To say that your authority doesn't know the difference between a profit and loss account and a balance sheet? Very unfortunate.
Well,
Page 70.
this is also the law.
And they said that I have not uploaded profit and loss account.
Page 70 also. This is also a profit and loss account.
No, that is a balance sheet. And this is a
Page
Yes.
71 is not the profit and loss account, it's the balance sheet.
Dr. Kindly see 70. Dr. Kindly see 70.
Page 70 shows 64, 32,
Yes.
450.
This is a profit and loss.
Yes, that was asked.
So this,
Profit
yes.
and loss account for the year ended 31st March.
So this is 64 lakhs and odd, much more than your requirement.
So, but then you have 71 million.
That is a balance sheet.
71 is the balance sheet, sir. You are on profit and loss account. This is the first issue. Secondly, please come to page 27. On what ground have you rejected? Once you say that the petitioner has not uploaded the PNL account, then in the report you say that the PLN account doesn't tally. So it's a false statement on your part? Yes. Please come to page 27, the ground of rejection.
There is a last paragraph. In compliance, the above provision in the participating entry is required to upload profit and loss account statement in support of their annual business turnover positive. But you have
Yes.
failed to upload the valid document, namely profit and loss account, which that amount to negligence in that bidding procedure. So, we have
So what is the fault on the part of the petitioner?
he failed to upload the valid documents of the profit and loss account balance sheet.
So how have you come to know that it is 23 lakhs and odd and not 64 if he has not uploaded at all? Let it be disposed of.
Yes, ma'am.
Petitioner has a very good case.
They are, Loshi, they have.
Please, Mr.
Dr. Kindly note, you have uploaded, but that is not correct. Balance sheet is uploaded.
Please come to page 27. On what ground have you rejected? You say that the profit and loss account has not been uploaded. You develop a new case in your report and say that it is wrongly uploaded. Can you do that? Yes.
Only thing is not, when they made an application for registration, they have uploaded. But at the stage of bidding, they have not uploaded.
Sir, what is the ground of your rejection?
They have not uploaded at the time of bidding. They uploaded on the registration at the stage of registration.
It cannot be uploaded every time. It is uploaded only once at the time of bidding.
No, but my they should up.
We are spending time unnecessarily.
That's why wasting judicial time. Judicial time waste. And they are treating balance sheet as profit and loss account, my lord.
The balance sheet is, kindly see that the balance sheet profit and loss account is there at 64 lakhs, and they are saying that balance sheet of 23 is the profit and loss account, which is not matching with what I have declared. They do not, Lordship. Apparently, it appears they have failed to distinguish between profit and loss account and balance sheet.
You say that, learned counsel says that it has not been uploaded, but upon seeing that, you've said that it's not matching. So how do you say it is not uploaded? During scrutiny of bid, it is found that the turnover doesn't match. So it was uploaded? And you have considered the balance sheet, not that profit and loss account.
Well, concerned now.
Yes.
Is the bidder not at the stage of bidder not? They uploaded the balance sheet 23 lakhs.
You are not concerned with the balance sheet at all, sir. You are concerned with the profit and loss account.
No, not.
Let us not waste further time.
Yes, yes.
Please take instructions and come back.
Now, you kindly, Lordship, direct them to refund the security deposit, because why I say, my lord, balance sheet is different with profit and loss account. They are saying they are treating the balance sheet as the profit and loss account. From the submission, from the instruction, it's appearing.
Roy, when the court speaks for you, why
you
are you repeating your submission?
Kindly set aside, kindly direct them to refund me, my lord. They're illegally enjoying my money. It's a wrongdoing on the part of the office.
I have expressed my mind. Let them take proper instructions and I'll give you a short. Sir, please take necessary instructions because you have no case at all.
But tomorrow, Lordship.
Yes, tomorrow. Tomorrow.
Very well, not today.
Not. Well, whatever is there, my lord, they cannot change it because they are taking contrary stance.
Change cannot be improved upon. Come back tomorrow. Not today, Guru. Next.
Well, I am big privilege. In this matter, I am appearing on behalf of the petitioner. Or here in this case, I applied for grant of permanent stage case permit on the route, Novaphat Bardhaman to SUVRA. Kindly see page number 18. My lord has got it. Page number 18. 18.
Yes.
The route has been mentioned, serial number 23. Serial number 23.
Yes.
My route has been mentioned and matter was placed before the RT board meeting held on 30th September 2029.
So this is deferred.
Decision of RT board. The applicant is present on hearing and going through the case record. The matter is deferred until compliance of rule section 88 of the Motor Vehicles Act 1988 due to route is partly covered by Birbhum district. According to section 88, if any route permit route is covered by two regions, and without countersignature of the other counterpart, permit would not be valid. So before that, 103 is required to be compliant because before grant of permit, both the region will sit together, will take decision.
Yes.
And for this reason, page number 19, Regional Transport Authority, Regional Transport Purva Bardhaman, requested white memo such and such dated 2nd January 2020, requesting the Secretary Regional Transport Authority, Birbhum, second paragraph, you are requested to finalize a date of joint conference, preferably through video conference.
Yes.
More in consultation with the RTA board of your district. My lord, that no response. Again, my lord, page number 20. My lord, a reminder was sent, same, for no objection. And page number 21, also same. My lord, reminder was sent. My lord, page number 22, this is the fourth step. My lord, I requested RTS Secretary Regional Transport Authority, Purva Bardhaman, requested that Secretary RTA to take a necessary action for joint conference. Now, page number 23.
That is the no.
Yes. Then they ultimately, my lord, they agreed, and my lord, this and informed that they have no objection for the issuance of permanent stays permit in favor of the applicant, Sri Nasiruddin Hussain, on the route such and such, only subject to final fixation of class 3 timetable with the existing GHOSH operators. Well, after obtaining the NOC, next page, the offer letter was issued.
Yes.
And on certain terms and conditions imposed. And page number 25, permit fees and counter fees has been accepted. And next page, page number 26, permit was issued by the Regional Transport Authority Purba Bardhaman. And after issuing the permanent stays permit on this route in question, along with the timetable, was sent to the Secretary General for counter signature. Page number 31. Original part of A and B of the permit was sent along with the malot application fees also for counter signature, and informing that we have accepted 10,500, including the counter signature fees, requested to countersign. Original malot documents malot are under the custody of the Regional Transport Authority, Bardhaman. Page number 32, along with the requisite fees, was sent to the counterpart. Well, no answer from the date it was sent on 10th October 2023. In the meantime, actually the vehicle was purchased after taking the loan from the bank. Bank, my lord, has issued a notice. Then, my lord, I compelled to make a representation before the chairman, District Magistrate Birbhum. My lord, kindly consider my prayer because my permanent original copy also followed under the custody of the Regional Transport Authority, but Birbhum for counter signature. But till date, no such decision has been taken, and it has no counter signature was made. So ultimately, my lord, after issuance of permit, I purchased the vehicle. I have no fault because after issuance of offer letter, I have. So kindly direct the my lord Secretary Regional Transport Authority, Birbhum, to send to forward the after counter signature because they have given them NOC, and on the basis of that, I am entitled to apply the vehicle because permit was issued. I have no fault. We have no fault.
Yes, Mr. Devra.
So far, the timetable is concerned. My lord, the conditional timetable was issued. If there is any dispute, Rule 109, if there is any dispute, the decision of the authority is final. So under 199, the authority will call both the parties if there is any dispute of timetable. This is the one that settled. This is a settled by this court of this.
Yes, Mr. Devra.
Instruction of the RTA bill. How can be initially communicated to the RTA?
No objection was granted initially.
No objection granted has been rejected. While on the ground that there after inquiry they are saying that the major portion lies with the RTA bill, not RTA bill. That is why this counter signature cannot be. It is the fact in case Lordship can direct the RTA board to consider its representation and issue the necessary order. Because necessary order has been already been communicated to the RTA pool.
Rejecting the NOC.
Due to major portion.
No, without hearing. Without hearing. Well, after NOC.
The hearing can't be given and thereafter.
Fourth memo was issued. Ultimately, in the fifth memo, he has given the NOC on the basis of purchase the vehicle. What is my fault?
Already rejected and communicated to the RTA.
Without hearing, how you reject it? Well, it is hearing the he could reject it. No, there is no question of hearing because on the basis of NOC, because in the fourth round, my lord, on the basis of fourth memo, no, because I am the litigant is suffered. This is no fault. So after the counter signature, my lord, that is regularized. Permit will regularize because he is the part of the counter permit authority. He is the part of the permit authority.
Rejected, please come back with the documents. With the documents.
My soft copy is not.
No, NOC has not been rejected verbally. There must be a communication.
On 10th October, since 10th October.
they are inadvertently that has been given. They are not inquired. Subsequently, they are inquired the entire route length. Then they found that about 12 kilometers beyond it, 12, 11 point something.
So that is within permissible limit.
Yes, then no problem. No.
Major person lies specifically. He can fly his vehicle within the Bardhaman region. There is no
No, no.
difficulty.
What is my submission? My lord, after my lord,
What is the solution? The permit has to be issued by the.
yes, sir, permit was issued here on the basis of no NOC.
বলতেই দিচ্ছ না সলিউশন
আরে solution আমি বলছি তো কাউন্টার সিগনেচার করো
তুমি সলিউশন করো
No, I can solve. Both the authorities are permission authority. He is the permission authority, counter signature authority. But he is also the part of the counter signature. That means he is also part of the authority, permission authority, because he accepted and honestly was issued on the basis of I purchased the vehicle. Permit was issued on 10th October, my lord. It was sent on the original. At till date, after four months is over, no decision was taken. No, I have not been communicated. I am in the dark.
That is the reason I'm asking for a report. With the
Yes,
documents.
yes.
Yes, sir.
No, how are you? After 4 months, because till date I'm no answer was given.
Last December they have produced it.
No,
Last
then,
December.
no, permit was issued on the basis of. Well, can I see the permit? Can I see the permit? Kindly see the permit. Permit, page number 26. Permit was issued.
Challenge that.
No, permit was issued.
Document. That will be better.
Permit was issued 10th October 2020, 23. October 23 on the basis of vehicle. On production of the vehicle permit is issued.
In any case, beyond the region, they cannot.
No, this is what is my fault. After they examine, then the permit was issued. That is the fault of why the litigant will suffer.
Whatever fault it is, it has to be in accordance with law and the rules. It
No,
cannot go beyond
counterside.
that.
The moment the permit is countersigned, that is regularized. On the basis of NOC, no, without countersign, without countersign, yes, I know that. Without countersign, the permit cannot be applied. Vehicle cannot be applied. But the moment the permit is countersigned, because he has on the basis of his NOC, the permit was issued, I purchased the vehicle. So 10th October it was sent for counter signature. The moment it is regularized. Permit regularized.
What happens if major portion of the route is in Birbhum?
When at the verge of stage, when the litigant, what the position of litigant?
Can the Birbhum authority still issue NOC?
No, without my lord.
If
Yes,
the major portion of the route is under Birbhum authority, can the authority still issue NOC? And
now
not
kindly see the
signature?
kindly see the
What does the law say?
kindly see the decision of the RTA Purva Bardhaman. Partly covered. Page number 18.
I have seen that, but
Partly covered. On the basis of that, without any inquiry, why the NOC was issued? Without inquiry, why NOC was issued? On the basis of the permit issued, not on 10th October, my lord. Yes.
It is contended on behalf of the petitioner.
So without hearing.
That is
That the petitioner
No, how
applied
there is a scope of challenge.
stage carriage permit
in
the inter-regional route from Nawabhat Burdwan to Shiuri, and upon receipt of no objection certificate from the Regional Transport Authority, Birbhum, permit was issued in his favor in respect of the said route, which was sent for counter signature to the RTA Birbhum. Stop. The permit is yet to be countersigned. Paragraph. Learned Counsel for the respondents submits that the RTA Birbhum has subsequently rejected, cancelled the no objection certificate issued earlier on the ground that major portion of the route in question falls within the jurisdiction, falls within Birbhum.
What?
Learned Counsel seeks to submit a report in the form of affidavit annexing all relevant documents. Paragraph, let the matter appear under the same heading. Or
So I'll record my submission also. Record my submission also. On the basis of the NOC, the permit was issued.
I have recorded your submission.
Yes, that is there.
20th February.
20 is not long because permit.
There are several matters. Hearing matters.
Hearing.
3:30 fixed as well. There's a specially fixed matter at 3:30. A matter has been specially fixed at 8:35. Who is appearing in this matter?
Rajib, I appear on behalf of the petitioner in this matter. Rajib, on the last occasion, we had already concluded our arguments. We had also filed a written notes of arguments. I'm being led by Mr. Obrajit Mitro and Mr. Senior Sharbhopi Mukherjee in this matter, Your Lordship.
What about the respondents?
I appear. They were supposed to argue on that.
No, we had already concluded. We had filed a written notes.
I believe Mr. Talukdar has also concluded.
Yes, Mr. Dotto argued that.
Yes, yes. So it was concluded on the earlier day. So it's only the KMD who are respondents, isn't it?
Yes. Our action has been challenged.
Yes, so you don't need to make any further submission, right?
My Lord, we have, Mr. Dotto has concluded and only one or two judgment he wanted to refer, my Lord. Mr. Dotto today, I think he's
not available.
I could not contact him. Whether he will rely or not. On the other day, Mr. Mitro was also telling that he will take 5 minutes time
For reply, yes.
for reply.
If they submit anything further.
Not to reply.
So, another day can be fixed.
Only we will not argue. Mr. Dotto will not argue. Only hand over the copies of the judgment because he argued on that.
So please make
principle.
over the copies to learn it
Yes,
beforehand, so that she can go through them.
And if we don't do that, Lordship,
yes,
whatever judgment we have relied,
that is
yes, that they have the notes.
So when will you come back? 7th February.
7th February.
Yes, marked at 3:30.
Great.
It's heard.
If he doesn't want to rely anymore, then the Lordship will conclude.
Concluded, yes. By consent of the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on 7th February 2024, marked at 3:30 p.m. Just a minute. Shantanu, 7th February 3:30 matter kichu ache kina dekhun.
My Lord, our matter is fixed. Both Mr. Mitra and myself is there. So this will not take time.
This shouldn't take time. Yes. Let it appear. Yes. Let it appear.
Because Mr. Mitro will not argue anymore. So we will not also only hand over the copies, and
yes,
if we do so, then we will supply a copy to them also.
Yes.
Grateful, Your Lordship.
Yes, 7:57.
Well, this is a very small matter where I'm appearing for an intervener, praying for leave to intervene in the main writ proceedings because I consider myself, in my humble submission, both a necessary as also a proper party.
When have you filed your application?
Well, my application was filed.
Not, Shantanu, 2 of 24 can.
Yes, this is 2 of 24.
We have not been served.
The copy?
No.
11 Service colony. Copy চাইছেন Judge Sahib. My lord grants me a moment. But I just tell your lordship, my lord, perhaps nobody will be troubled.
A copy needs to be served.
Service কি হয়েছে দেখতে পারবো?
No, we have not received. I have not received it.
বার করে রাখতে পারে না। Service হয়নি?
No, আমার উপরে।
Mr. Dey, have you received a
Are
copy?
you for the representation?
না, আমি came.
Have you received a copy of the application? Intervention?
Well, then I
Why don't you serve
have
and come
to.
back, please?
money. List করে। Yes, my lord, in fact, if my lord, after hearing the matters, of course, I shall serve them. Keep it any day next week, my lord. In fact, next Monday itself. My lord, if I'm given leave to intervene, my application can be treated as an affidavit. It's a very small point of law involved, nothing else. I am, my lord, for the West Bengal Highway Development Corporation Limited. My lord, I have been entrusted the task of building, my lord, a particular six-lane highway in Belghoria. My lord, for which I have to purchase land that has been ratified by the West Bengal Public Works Department. I'm the petitioner in the intervening intervener.
27107. Who is appearing for the petitioner?
Samim Ahmed.
Well, in that case, kindly give a blanket direction, my lord, for service on all appearing parties, my lord, and including the writ petitioner. I want to be heard in the writ petition.
I think one contempt application is also pending. One contempt application was also pending. I don't know whether.
Well, this is the affidavit of service.
Contempt application has been disposed of.
Well, this is the writ petitioner, my lord, has been served. Kindly see the
Please serve the respondents and come.
respondents service colony. Well, kindly let it retain its position, my lord. I shall serve it in the course of tomorrow itself, if possible. No, I'm saying kindly keep it for next Monday.
Let me see. The proposed intervener is directed to serve copy of the application being Can 2 of 2024
Monday week.
for the respondents
Monday week.
and file affidavit of service on the adjourned date.
That means 12.
12th.
I was wanting it next
12th?
Monday. Next Monday.
As per my lord, he is contesting the petition, and on that day, my lord.
So when do you want it on 5th?
5th.
5th?
5th.
In that event, my lord, I will.
I pray for, I pray for I find from the affidavit of service that the state has also been served. This is the affidavit.
Instead of 5th, my lord, let it be on 6th.
So, my lord, as immediate participant candidate of the bar association, my lord.
Who is the contesting candidate?
Samim.
Oh.
Only for that reason, my lord, I am something. Otherwise, my lord, I.
So 5th, he may not be available. That is your submission.
Instead of 5th, let it be on 6th the following day. 6th cannot be there. Let us go. 7th.
Is 7th inconvenient, my lord, if I may ask, or my lord takes these 3:30?
7th, very well. 7th. 7th.
Yes.
7th.
No, Mr. Dey is apprehending that he may not be available on those days.
No, 7th, he said he will be.
Petitioner.
The petitioner is here. They have been served.
Day after tomorrow? Last voter within last. Day after tomorrow, Lordship.
Fine. Fifth,
Next Monday, 5th.
next Monday. Yes.
Let the matter appear under the same heading on 5th February.
But my lord, the affidavit of service shows that the writ petitioner and the state of West Bengal have both been served. These are the most
Why don't you make over another copy to them?
Instead of
Okay,
fifth,
so-
I was praying, can it be on sixth, the following day?
6th is
My lord, Monday, my lord, fifth is the monthly list.
It
It
fixes
might
day
get
after
lost.
tomorrow.
My lord keeps it day after
tomorrow.
tomorrow. Since
Yeah,
the writ
tomorrow will
peti-
not be possible.
Oh, I'm
There are
Then Monday,
several
Lordship.
matters.
then sixth or seventh?
Seventh.
Seventh.
7th.
At 3:30.
It's taken up at 3:30.
Very well. Let it retain its position, my lord, as the first matter in the list.
It will because it's a 2017 matter.
Very well. I'm very grateful.
Next.
I'm for the petitioner, Your Lordship. Your Lordship, the issue in this writ petition is covered by Your Lordship's judgment as well of the Honorable Division Bench and Supreme Court. Your Lordship, the issue is
Who is appearing for the
respondent.
Mr. Day is appearing.
Yes, Your Lordship. Your Lordship, the issue is whether the petitioner is entitled to mutation in respect of a Salt Lake property on the basis of will, probate of which has been granted by the Honorable High Court at Calcutta. Your Lordship, may I have prepared a short list of date. May I please hand over?
You wanted to reaffirm the affidavit in
Your
reply.
Lordship, that has been done, Your Lordship. It was not, it couldn't be traced in Your Lordship's records. That's why, Your Lordship, we have reaffirmed.
Let it be recorded.
Yes.
Your Lordship kindly takes up my list of dates, Your Lordship.
Please give a copy. to
Yes,
Mr.
Your
Day.
Lordship. Sir, copy. Sir, Your Lordship, this matter is come up for hearing. Your Lordship would kindly hear me. Yes.
On the previous occasion, my lord, I plead for from my lord, everything to opposition. But I may not want to file, not to file but a short note, my lord, short instruction, respect to the my lord. Short in it.
Mr. Day, you have to come on affidavit because
Your Lordship,
reply has been
Your Lordship, they filed affidavit. Your Lordship, kindly, Your Lordship allows me. Your Lordship, they filed one affidavit.
filed an affidavit.
Yes, Your Lordship.
Or that is
But
my
And
extension of
Ye-
time was
Yes, Your Lordship, I will explain, Your Lordship. Your Lordship, there are two writ petitions.
Mr. Day, something, please, madam.
Your Lordship.
Yes, Mr.
my lord, because my lord, I am not all the fights, my lord. After that, my lord, my lord, give me all the fights, and I am. My lord,
Because on the earlier date, you sought extension of time to
yes,
find
because my
affidavit in
lord,
opposition.
now I have seen that there is a one affidavit in opposition. But that is my,
On record.
Non-injury
in opposition.
হ্যাঁ
No, I do not find any.
Your Lordship, it is affirmed on an affidavit which has been affirmed on 3rd September 2021. My learned friend's affidavit.
Third September 21. No.
Your Lordship, it is also annexed by me in my second writ petition, Your Lordship.
Mr. Day, you have not come up with your affidavit in opposition.
Kindly give Dorchetকে একটা কপি দিয়ে দিন আপনাদের affidavit. Your Lordship, I have my copy. May I hand over?
He has to file his copy first.
Your Lordship.
Because the reply is on record, affidavit in opposition has not come before this court. And in the second petition, nothing has been filed.
Your Lordship, yeah.
But it is not filed, Mr. Dev. Please file your affidavit in opposition. On the last date also you sought time.
Your Lordship, may I make one submission? Your Lordship, this is a covered matter. Your Lordship would kindly hear me, Your Lordship, because
There should be one affidavit in opposition from the state.
Your Lordship.
It is not there on record.
Your Lordship, we have a copy.
That
They
will
have
not
served.
suffice. Do you think it will suffice?
Your Lordship, the urgency is, Your Lordship, they are seeking to resume my land. And Your Lordship, that's why, Your Lordship, it's a little bit urgent for us, Your Lordship. But Your Lordship, we have come to know only by their affidavit, Your Lordship. And that's why the second, Your Lordship, it's a very short matter, if Your Lordship permits me.
The affidavit in opposition has to be
Your
on
Lordship,
record.
I must take that.
It is not there with you.
Your Lordship,
Because a reply has been filed to your affidavit.
their copy, your affidavit. Sir, your affidavit.
আমার ফাইলই নেই তোমরা তো ফাইলটা সাবমিট করো my lord they give me a copy as my copy was not
file क्या उस पे agreement
But you have to file an affirmed document before this court.
my lord I must file
Your Lordship.
You have to file the affidavit in opposition. You have not filed it at all.
Even orders. Your Lordship, they are intentionally delaying the matter, Your Lordship. Your Lordship, Your Lordship, they've served me with an opposition. I have filed my reply.
Received the opposition.
Your Lordship, 2021.
opposition to the
Your Lordship, it was received on 9 September 2021, Your Lordship.
down opposition
Your Lordship, may I hand over? He wants to see his opposition, the copy which I have.
my lord in this matter my lord I was not the advocate.
Your Lordship, whatever it is, Your Lordship, I am suffering, and Your Lordship, on every occasion,
I was appointed
on
my learned friend, my lord,
This is after change of panel. This has happened.
join me now. He is not panel.
Your Lordship,
Yes, there was one Mr. Shushantu Kumar Mukherjee and Ms. Ujani Paul.
After that, my lord, I was appointed and they give me a copy of the
so Your Lordship, we have a copy we can hand over to Your Lordship. That is,
He has to reaffirm in that case. You cannot hand over an opposition to this court. You are the petitioner.
petitioner, Your Lordship.
Please bear that in mind.
I understand, Your Lordship.
A submission for no reason at all. Mr. Dev, please come back with your affidavit in opposition. Learned Counsel for the State Respondents seeks further extension of time to use the affidavit in opposition as called for.
instruction করে দিন না affidavit কি হবে
জয়সেব যদি করতে my lord
আপনি বলে দিন
আমার কোনো আপত্তি নেই my lord
Your
আপনি
Lordship,
তো বলছেন affidavit করবেন না
You'll take a copy of the affidavit in opposition which
my
is
lord
already filed.
said if
Your
you
Lordship.
said that will be hard.
Your Lordship, what I am trying to say, Your Lordship Your Lordship suggested that this instruction may also be put on affidavit. So
Yes. So
Your
you
Lordship,
come
both
back
can
with
be
an-
done.
Yes.
Your Lordship, there may be a direction that this may also be put, because there are two writ petition. In the second writ petition, they want to rely on this instruction. Let them put this also by affidavit so that we don't waste
There will
further
be a
time.
comprehensive affidavit in opposition which covers both the writ petitions.
Your Lordship, one they have already filed, already served, and I have filed a reply before Your Lordship. So Your Lordship, this cannot be changed
I do not know.
because I have filed my reply.
What I was suggesting is why don't you hand over a copy of the affidavit in opposition to Mr.
Yes,
Dev
Your
if he
Lordship.
doesn't have one.
Yes, Your
And
Lordship.
he can add this instruction also to it and file a comprehensive affidavit.
But Your
Both
Lordship,
matters.
Your Lordship, what I was suggesting, this affidavit, Your Lordship, let it be like this because I have already filed a reply to this.
You
And
have an opportunity to file an additional reply
Your
also.
Your Lordship, that will cause further delay in the matter, Your Lordship.
Let the
Let them
matter
file a
appear.
affidavit, whatever, Your Lordship, it is, whatever they want to file, Your Lordship.
Please hand over a copy of the affidavit to Mr.
Your Lordship, I will get it xeroxed and give him a copy.
19th.
Your Lordship,
19th
this matter
February.
may be given precedence, Your Lordship. It was already
It's
upgraded.
being given precedence and you are not ready. What to do? Mr. Dev, please come back with your affidavit on the next occasion. Next.
And your lordship, it may be recorded that this is the last chance for them to file affidavit. Last time also they took time, your lordship, for affidavit and they've not come up with a.
Come back with this.
Your lordship would kindly
Next.
wait.
দিয়ে দিচ্ছি এটা জিরো করে দিয়ে দিচ্ছি ফরওয়ার্ডিং লেটার করে পাঠিয়ে দেবো
Next.
But I appear for the KMDA, the principal respondents in this matter.
Your opposition?
Opposition, oh, sorry. My lord, it is affirmed, served, since the matter,
Is appearing for the petition?
my lord, I'm filing my copy. Mr. Sumanto Sarathi Bhumik.
Several councils appearing.
Several councils.
Washington,
They have,
Rao,
they
Mizoram,
have,
so
they have served me an affidavit reply also. Kaushik Vishwas, yes, ultimately Mr. Kaushik Vishwas has served me the affidavit in reply. Earlier, there were,
but he is not representing the petitioners.
no. I have served,
It goes back to the monthly list because petitioners are not there.
I have served the copy of my opposition in December 2022.
Affidavit in opposition submitted on behalf of the KMDA is taken on record. Paragraph none appears for the petitioner. Top no accommodation is sought. Paragraph let the matter appear under the same heading in the monthly list of February 2024.
Much.
Next.
My lord, 761, Mr. Owen Banerjee is appearing for the SBSTC, my lord.
Yes.
My lord, he is.
Petitioner? Petitioner, anyone? None appears for the petitioners. No accommodation is sought. Dismissed for default. Next.
I'm appearing the state.
We are
State.
applying for the state respondent.
Petitioner?
Bidyut Boron Vishwas.
Petitioners are no longer interested.
For us, it is not interested.
None appears for the petitioner. No accommodation is sought. Dismissed for default.
762.
762.
Join the full order.
763, my lord, on the last occasion, your lordship had directed us to give notice to the other side. But we had given notice, my lord. This is the order and the notice. If since they're not there today, my lord, may I give one more notice as a last? Shondeep Dashgupta, Fox and Mund. This is Hitco on the other side.
Only Hitco. No one for the only Hitco.
Yes, my lord. Yes, West Bengal Housing and Development come.
Affidavits are exchanged.
Yes, affidavits. Yes, my lord. It was ready for hearing. Otherwise, in fact, quite some time back, my lord has heard the matter initially. I'm led by Mr. Mitro. He's not there today, but if your lordship keeps it next week, I'll give one more notice. And in case still they, even after that, if they don't appear, my lord, I'll request your lordship, my lord, to proceed. My lord,
Does that really help?
that's also the problem.
Of the respondents.
If my lord,
State is also there. Who's appearing for the state?
798. My lord, the
Did it
order.
appear all throughout, I think, is it?
I do not think the state has
Appear
appeared.
all throughout.
Initially, they were appearing. It was Mr. Choyan Gupta had appeared with.
Hitco.
For HITCO, for HITCO.
Yes, for the HITCO.
Yes.
Please inform him in the meantime.
Then my lord kindly makes another order. My lord had already directed, and in terms of the direction, my lord, we have already given them notice.
None appears for the respondents despite service of notice. Paragraph, let the matter appear under the same heading. Do you think it will help if I hear the matter in absence of the HITCO?
But if my lord gives a direction that in case they don't come, they don't appear, my lord will proceed.
Would like to record that line.
Yes, then there will be some, at least some pressure on them.
21st February.
21st February, I'm grateful.
Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
I'm grateful, my lord, deeply obliged.
But I appear for the KMDA.
Well, I am for the petitioner.
Yes.
Although the facts of the case is very short, but my lord, it's
Who is appearing for the state? The State Cooperative Society, there are several respondents.
there are several respondents. My lord, only my lord.
Is it who is appearing for the state? Affidavits exchanged.
Affidavit, so for KMDA is concerned, my lord, we have not filed. The
KMDA filed affidavit in opposition.
Huh?
Filed. KMDA.
Copy nahi karna.
State also filed affidavit in opposition.
Copy nahi karna.
I do not find anything recorded.
But my lord, in
No,
my
no.
brief, my lord, the copy of affidavit in opposition,
You filed a reply to that?
I filed reply to that. Reply to
Affidavit in opposition reply which was given.
আমি ফাইল করেছি
এই যে কপি নেই
না
আমাকে যেটা চিঠি লেখো কপি দেবো
ও চিঠি লিখতে হবে
The reply is on record.
reply is on record. But a state has also given, my lord, the KMD also given.
oh sorry I've got
Got it? If lordships records
They
is
are on record. Affidavits are also there.
also there.
But the respondents are not aware.
কি বললো করবে hearing they
Yes.
start করবে না
This is by the state and this is by the KMDA.
yes my copy I've got I'm sorry
after a long time the matter is being heard.
Yes.
Short
matter.
it will take time.
My lord, the fact short, but the law is huge because I indicated your lordship. My lord, what happens here? My lord, the petitioner.
I don't think so. Yes.
My lord, the petitioner, my lord, became, my lord, the petitioner are the legal heirs of the.
Continue. I'll release the other matters.
My lord, it will go on for long time. My lord, it's not even complete in one.
Can start today.
There are issues whether the writ petition, by filing a writ petition, whether the decree of a civil court can be executed through writ. The question is involved here. He has to substantiate that.
That is not the issue.
That is the issue.
That is not the issue.
Will you start? In that case, I have to release the other matter.
কি করবে বলো তুমি করতে চাও? I want to do that.
We may come back on some other day.
You have the first right of audience, sir.
Yeah, that's up to you. Because we have taken that point.
I'll adjourn on your prayer.
Lordship,
I'll adjourn on your prayer.
not on my prayer, my lord.
Then,
My lord, then, my lord.
why don't you start? Let me release other matters for the day.
Yeah. Whether the state is ready, but because state is principal respondents here. Yes, petitioner would take.
Start today.
Let us then start.
For the day.
The petitioner, my lord, may I just give the fact in a nutshell and then I will take your lordship to the document and then the case. But the petitioner are legal heirs of owner of a property. Now, my lord,
predecessor of the petitioner was owner of diverse property.
Owner of?
Diverse property. Now, my lord, in respect of all the property.
Yes, continue.
Now, my lord, in respect of other properties, there is no dispute. The dispute revolves around, my lord, only in respect of Notun land. In respect of Dag number 3813, which is having 3.35 acres of land. My lord, the issue before your lordship is that in respect of other Dags, my lord, acquisition complete, and my lord, also, my lord, the predecessor in interest received, my lord, whatever award was awarded. And that in respect of award also, the predecessor of the petitioner never had any objection. And that came into finality. Now, my lord, the problem started with this very Dag, which is, my lord, Dag number 3813, having 3.35 acres of land. Now, my lord, what happened, my lord, when the award passed, my lord, it was, my lord, we objected that. And my lord filed a reference before the civil. Now, my lord, before the civil court.
Said that the predecessor did not object to the award.
No, objected, not in respect of other properties, only in respect of these Dag number. Now, my lord, when we objected, my lord, and my lord, the petitioner's predecessor's prayer for, my lord, the enhancement of the award was granted, upheld by the court. Now, my lord, the question is, my lord, such order was passed long time back, my lord, in 1981. And thereafter, my lord, there was no payment, nothing was given. And the property was taken, developed, and everything. Now, my lord, the question now is that, my lord, if, my lord, in respect of an award or an acquisition, if, my lord, the compensation has not been paid till, my lord, filing of the writ petition, whether we can say that acquisition has been completed or not. Or, my lord, if acquisition has been not completed, then, my lord, whether we are entitled to get, my lord, rate at the market value or not. That is the sole compass or sole issue before your lordship. Now, my lord, very interestingly, my lord, when this writ petition was filed, then, my lord, they came up, the respondents, saying that, see, we could not pay you the award, and this is the amount. Now, my lord, this amount, this letter came admittedly after filing of the writ petition. So they also admit that this amount, which was in that year 1980s, was not paid for last, my lord, maybe 40 years, not paid. So this is the issue before your lordship. Now, my lord, very short, my lord, the facts may I place before your lordship, and then, so my lord, my submission before your lordship. Now, in reply to this, they say that, see, as the award has been passed, the acquisition completed, so you are not entitled to anything. All you are entitled to is that enhanced award or nothing else. So, for this period in which we have not received any money or whatsoever, it's nothing. Take the money, go. And they say, as the award has been passed, maybe I have not paid. The question of payment in the present market value also does not arise. They have also taken the point of delay. So these are the defense of the other side. Now, my lord, very shortly, my lord, may I take your lordship to the relevant documents. Now, my lord, I have here disclosed, my lord, the all documents. How, my lord,
has been taken? Possession of the property?
yes, position taken, developed, and everything. Everything is done. Now, my lord, straight away, I will not waste, my lord, lordship will see from the writ petition, I have annexed everything, the copy of the gazette, notification, then everything I have disclosed. Kindly straight away come to page 106
What was the ground for not paying the compensation for such a long time?
Nothing. There is no explanation also. I will show you, Lakshmi. I am going to show you Lakshmi 4 documents, not more than
A
that.
12-2 notice was also not issued upon you for payment of compensation?
No. No. Not even in the affidavit in opposition. No, nothing. Kindly come to page 106 first.
Yes.
Well, that property is very lucrative. If Lordship goes from Goriahat towards Koshba, the left hand side there is a big cooperative complex, and that is the land belonging to my predecessor. It's not that the land is not lucrative or something like that. 106, if Lordship takes, well, this is the copy of the award. Lordship will find page 106. It is, Lordship will find description, situation, extent of the land, Koshba, JL number 13. Then, my lord, description of the land, that is whether following vacated homestead. Now, my lord, plot number 3813, 3814, 3815. We are concerned with 3813 only. So, land value, Shali of lands have been valued at such and such, such and such. So, date kindly mark 23rd March 1981. Then Lordship skip these pages and Lordship
March.
yes. So the award compensation amount next page is 166,455 in total. Then my Lordship kindly takes, my lord, kindly comes to page 112. Then my lord, we approached to the civil court. Lordship will see.
This is a reference under section 18.
This is the reference under section 18. Lordship starts from 112. Lordship will say, in case of referring claimant, in short, is that 3.35 acres of land out of RS plot number 3813, Mauja Koshba, PS Jadavpur, now Koshba, was acquired by State of Housing Accommodation for members of Nilachal Housing Cooperative Society Limited in the land acquisition collector. Then, my lord, case number such and such, the petitioner also states the land in question was owned by such and such. Now, my lord, then after them, their has sold, the heir sold up, they've sent to such and such. On such and such, sold the land in question of Soilendra Day, the petitioner in the present case. By a Kobola, the petitioner also states the opposite party has no right to get compensation as they are not entitled to any interest in the title in the 3.35 acres of land for the time of passing of the award. They say, I have no owner. Now the question is whether petitioner is entitled to get compensation as claimed by him or not. The OP did not contest the suit, though they were noticed. The award made by reveals that a sum of such and such awarded in connection with the award in question. In support of this case, petitioner adduced both oral and documentary evidence. PW1, Soilendra Day, that is my predecessor, has deposed that this case and stated that he purchased the land in question from Tarapada Bandobadhyay, such and such, Kobala, consideration money. From his evidence is also evident he paid the rent after purchase of the said land. The rent received is marked. Opposite parties have no title to possession of the suit land. They are not entitled to any compensation. From Exhibit 1, it is also found Sri Soilendra Day is a purchaser and seller. And the seller is Sri Tarapada Bandobadhyay, who sold the land in question at a consideration money of such and such. The deeds are in original and was created 40 years ago. It reveals that land includes the land dark number such and such, Taliganj district Chokipur, land are mutated in the name of the petitioner Soilendra Day. In my opinion, the documents that is the same deeds in favor of Sri Soilendra Day and the rent received in the same name Soilendra Day support the present case. In that view matter, I hold that RC Soilendra Day is entitled to get compensation in respect of the quantity of land. The result of the present case succeed. Hence, it is ordered that LA case number is allowed ex parte, but in circumstances with cost, RC is entitled to get compensation of 3.35 acres of land, Koshba such and such. Award was made
By them, such and such collector is modified accordingly. So this is the award passed long time back, and thereafter there was nothing. They are continuation. I am not the owner of the land. Taking that cue, Lordship has to adjudicate whether the acquisition which has been went on without notice to me, whether that is also a valid acquisition or not. Now, this order is of, Lordship will find a long time back of 1987. So 87, the civil code under reference under 18 says that you are entitled to the same. Now, from that, thereafter, Lordship will find we have issued diverse letters to them also. Demand justice saying nothing. Nothing came forward. And that is disclosed, but I am not wasting your Lordship time. I'm going to take my supplementary affidavit. And that is very important here. After very, very short one. Supplementary affidavit. একদম পাওয়া গেছে 11 June 2018. Service. Copy আছে extra. No, the date of institution of writ petition is 2017. After it was filed, served on them, then my Lordship kindly come to page 4.
Give me a minute. I have not found the supplementary.
Oh, not it. একদম ছোট সরু দেখুন একদম সরু
ওটাতে কিছুই নেই এর জন্য খুঁজে পাচ্ছি
ওটাই সব থেকে ইম্পর্টেন্ট নেই কিছু না মামলাটা তারপরে হয়নি
Yes.
Now, 2017 we filed the writ petition.
Yes.
In 2018, page 4, kindly find
Of the supplementary?
Supplementary, page 4.
Yes.
The state woke up from the deepest slumber possible, a slumber of 30 years. And then they say, 6 March 2018, given to all the petitioners, being the legal heirs. And now I'll kindly come to the contention, which is page 5. LRA case number 71 of 81, arising out of LA number such and such, in the enclosing copy of the GO order 2018. So the order was issued of 2018. GO number 616, dated such and such, on the above notice subject, I am directed to request you to contract the additional magistrate, New Treasury Building, Alipur, for getting payment of decretal dues in respect of the above mentioned land acquisition case as early as possible. So it comes on from 2018. Then, see the government order at page 6. Sanction of decretal award in compliance with decretal order of Honorable Additional District Judge, South Chobbish Pargona, under section 18, in case number such and such, for 3.35 acres of land in plot number such and such, Koshba, Jadavpur, for housing accommodation of the members of Nilachal Cooperative Society. In cancellation of GA number 2017 on the subject noted above, the undersigned is directed to say that additional special LA Judge Court has passed an order of decree of 1988 in respect of LA case number arising out of such and such, under section in the matter of such and such, in case of 3.35 acres of land for housing accommodation for the members of Nilachal Housing Cooperative Society Limited. Accordingly, the aforesaid order of decree a sum of 1.37515 only is to payable to the claimant petitioner, being the principal component of the decretal award determined by the Honorable Court, had land loser have been further allowed a 9% per annum for 1 year from the date of possession and 15% per annum after 1 year. In circumstances stated above, undersigned is directed to say Governor is pleased to hereby sanction the amount of such and such for such and such. So 30 year, 3.35 acres of land. Then my lordship 6 minutes. As there is no charge provision for current year budget in new head account, expenditure should be made such and such, not relevant. Further sanction an amount of 7,17,000 towards payment of accrued interest only to the debited from the head of such and such, is pleased to authorize the additional district magistrate to disburse the amount. Order issued, finance department, such and such. So this is the thing, that after 30 years, for 3 acres of land, there was no notice even issued. They even did not recognize me as the owner. I got what? 1,37,000 plus 7 lakhs, so 8 lakh, 10 lakhs short for 3.35.
Steps did you take during this period? What steps did the petitioners take during this
Well,
period?
petitioner during this period
87 to 2018.
has wrote repeated latest. It's not that lordship will see. Well, there is also an event. My father also expired in between. My father, who got the decree, also expired in between, which is at page 128. Lordship will find the death certificate. Death certificate, we are not at that much of fault, Lordship will find. Death certificate at page 128. My father died, date of death, Lordship will find.
88.
88.
So 88
after
to
that,
2018.
yes, correct. After that, we really got knowledge of the matter after some time. And thereafter, we wrote letter that is disclosed here. It's not that case, but I was aware. It's my father's land who died after getting the decree. The decree was passed in 88 and he died. And thereafter, we also filed a petition before the third additional district judge at Alipur, 129. There is, I am not going to hide something from your lordship to get order. We have also filed a case before the court below by my father. Basically, I am not. But there also there is nothing, and thereafter lordship will find page 131, 2008. A letter was sent for this amount 2008, and thereafter lordship will find another 2-3 letter. Lordship will find another letter at page 138 of 2008, and then again in 2009, page 134. Then wrote repeated letters, not that was not their knowledge. Then lordship will again find a letter at page 139 by all the legal heirs. Again 141. (149) by the father, not by me. And then, lastly, we have issued. Oh, then lordship kindly sees. Oh, that portion after the matter was taken after a long time, my fault. Lordship will find page 143.
Yes.
Lordship will find here on repeated occasion, we went there and to meet the office. This is the lordship sees.
The visitors.
The visitors. So we said, I received a decree. What happened to you? Give me money. It's not that we never went. The lordship will find that these visitor slips of 2018, 15, 12,
Yes.
12, lordship will also find, my lord, repeated occasion we made inquiry, but there is nothing. Now, my lord, now in the opposition of the state, lordship, KMDA is not the requiring body. I don't think I have to, really address them. But at the opposition of the state.
Why don't you start with the opposition on the next date?
Yes. No, শেষ করিনি।
Let the opposition part be dealt with.
There are certain issues, let him complete.
That issue সবসময় থাকে।
You have made us party, so we have a right to vote.
Same heading on 26th February.
Yes.
That's it.